welcome you to HKAC's ADR in Asia conference today. We are very excited to see you all here and on our screens. I am Gökçe Uyar from the HKIAC, and I will be your MC today. My goal is to lead you through the event. So let's start with the housekeeping matters. Please scan the QR code and log in for the virtual function of the event to submit your questions. You can submit your questions through the Q&A box. If help is needed, please raise your hand. One of my colleagues is going to assist you immediately. If you see a question on the screen that you like, please push the light, and then that question, which is chosen the most, is going to end up at the stage. The conference wouldn't be possible without the support of our sponsors and supporting organizations. You can see their details on the screen, and you will see various logos inside and outside of the room today. In light of the COVID pandemic, this year we also wanted to do something meaningful and raise donations for Feeding Hong Kong. Actually, the participants of this event already donated to Feeding Hong Kong by registering for this event. Yes, the participation fees and on-demand fees have been donated to the Feeding Hong Kong. Well, if you feel more generous, I encourage you to visit their table and donate more. This year we have raised 150,000 Hong Kong dollars. One last stop before the event is going to be capturing this event with numbers. We've got the highest number of registrations for this year's Hong Kong Arbitration Week. 1,140 people registered. People signed up from 53 different jurisdictions, and for this conference, we have full house, 70 in-person attendees. And overall, including virtual attendees, we have more than 300 people. Without further ado, let's begin with the program. I would like to first introduce you to someone you very well know, and well, my boss, HKAC Secretary General, Sarah Grimmer. Sarah is going to update us about HKAC's 1 year. The floor is yours, Sarah.
She gets paid to say nice things about me. So welcome everybody to this year's ADR in Asia conference, the flagship event of Hong Kong Arbitration Week. I want to do three things with my time before you this morning. First of all, celebrate the fact that this is the 10th Hong Kong Arbitration Week. Secondly, give you an overview of what's been happening at HKIAC since we last met. And finally, I want to launch two new projects from HKIAC. Okay, so the 10th anniversary of Hong Kong Arbitration Week. Hong Kong Arbitration Week was born back in 2012. It was the brainchild of Karen Tan, my predecessor Qian Bao, and Dr. Michael Moser. And at that time, there were far fewer arbitration-related events in Hong Kong, and typically only the more senior partners and law firms would attend the few conferences that there were. And so the idea behind the first Hong Kong Arbitration Week was to bring together a cluster of arbitration-related events and to make them more accessible to the broader community, including younger lawyers. And I can see that the younger lawyers from back in 2012 are here today. Some of them perhaps not as young, but not too much more aged. So over the years, the Hong Kong Arbitration Week has achieved what it set out to achieve, but also much more. And it's really become a major event in the international arbitration calendar. Over the decade, more than 5,000 people have attended from over 55 jurisdictions. And the Hong Kong Arbitration Charity Ball has raised over $1 million for local charities and for other arbitration initiatives. So the impact of that initial idea has been enormous and has been felt far beyond Hong Kong. So what about HKIAC since this time last year? Well, as you probably all know, 2020 was a record year for HKIAC in a number of ways. We had the highest number of cases, 318, and the amount in dispute across our quantified cases was $8.8 billion, which is the highest amount since we started recording that figure. And like 2020, 2021 is also a very busy year. Our standing committees that make decisions in our cases, the appointments and proceedings committees, will together have made approximately 200 decisions by the end of this year. And what is really special about our standing committees is that they are comprised of experienced practitioners, barristers, arbitrators, and in-house counsel from Hong Kong and from all around the world, who truly understand what the consequences are of their choices in arbitrators, but also in their decisions on procedural matters. So that's important for our users, for legal representatives, and for arbitrators in our cases. Let me take this moment to recognize the contribution of one of the members of our appointments committee, Vincent Connor of Pinsent Masons, who very sadly passed away this month. He was, of course, a very highly respected and well-loved member of the Hong Kong arbitration community. Our work under the PRC Hong Kong Interim Measures Arrangement continues apace. Since it came into effect 2 years ago, we have processed 54 applications, 19 this year, and the mainland Chinese courts have issued preservation orders over assets to the total of $1.8 billion US. We trace our work under the interim measures arrangement very closely, and we publish it on our website along with a lot of other practical information for users whenever that needs to be updated. 2020, of course, was the year we all pivoted to virtual hearings, and that has not changed. In 2020, we conducted 80 virtual hearings, and this year we've conducted already 85. And last but not least, in May this year, HKIAC and Hong Kong were ranked third most preferred arbitral institution and seat worldwide in the 2021 Queen Mary and Whiting Case International Arbitration Survey. And this represents a 17% increase in ranking for HKIAC and a 22% increase in ranking for Hong Kong since the last survey in 2018. Okay, it's now my great pleasure to introduce 2 new offerings by HKIAC that we have been working on for some time. HKIAC Case Connect and HKIAC Case Digest. Turning first to HKIAC Case Connect. This is an online case management system, case management platform where parties and tribunals can communicate, upload documents, and track ongoing arbitrations. It facilitates document management by providing an enhanced online document repository. It provides an online case-specific calendar, and that calendar easily links to Outlook. And it centralizes all case-related information on one convenient platform. Let's take a closer look at the actual platform. Case management. Here you see the case information page, which is the home page of the platform. And this provides users with all of the an overview of all of the relevant information in a case. The activity page allows users to track the progress of an arbitration. The document page allows for users to upload and organize documents. The shared calendar allows for easy viewing of all dates and deadlines in a case. And Case Connect also provides a list of all participants in an arbitration and provides in one place their contact information. So as I said, we have been working on this for some time, and we have been testing it both internally and externally. And after we completed our due diligence with respect to the possible service providers, we decided to partner with Thomson Reuters. Their platform has been specifically designed for arbitration. HKIAC Case Connect provides banking-grade encryption, 99% uptime, and around-the-clock monitoring of servers. This means it's secure, it's reliable, and it's available whenever you need it. HKIAC Case Connect will be available as of tomorrow. We will provide it in cases administered by HKIAC or in cases where we provide ongoing administrative support, for example, in fund holding cases. We will provide that free of charge through the end of 2022. And that's with respect to cases that are already afoot or cases that have yet to be commenced. So if you would like to reach out to us to inquire, please do not hesitate to contact your case manager, anyone at HKIAC, or write to that email address, and we will help set it up for your case and train users for you. The next offering is HKIAC's Case Digest. This is a searchable database of anonymized and summarized procedural decisions by HKIAC. And the objectives of this is to provide more information on the decision-making process of HKIAC, which will enhance the institution's transparency and also enhance certainty for users. So the database is designed according to 3 searchable options, very user-friendly, either by applicable rules, by subject matter, or by keyword search. So, for example, if you would like to learn more about how HKIAC has decided contested expedited procedure applications in the past under our 2018 rules, what you can do is you can go to the applicable rules and then go to the relevant provision for expedited proceedings. Or you can go to subject matter and enter and choose expedited proceedings. Or you can use the keyword search and enter expedited procedure, and that will then take you to a case abstract, which is a very short summary of the decision by HKIAC. This is complimentary and available to all on our website. And then for subscribers, here are the terms of the subscription. You will be able to read more information, the case abstract, the arbitration clause where relevant background, and then the analysis and decision of the HKIAC. And this gives you a chance to view the kind of information that you would be able to see. What this is a summary of the decision-making of HKIAC based on anonymized and abstracted factors that arose in a past proceeding. HKIAC Case Digest will be available from the 1st of December. So there you have the 2 offerings. I hope that they are of great interest and use to you. So with those announcements and those overviews and the celebration of the 10th anniversary of the Arbitration Week, it is now my great personal and professional honor to welcome the Honourable Secretary for Justice, Teresa Cheng to HKIAC, our former chairperson. And Teresa, my great pleasure to hand the floor over to you for the opening remarks. Thank you.
Distinguished guests, ladies and gentlemen, it is a great pleasure for me to speak in the ADR in Asia conference. This year's conference covers important topics of arbitration, starting with those that are in place and fundamental to arbitration, to a look into the future trend. For parties to arbitration, the availability of interim measures is of paramount importance. The grant or refusal of interim measures may sometimes be determinative of the dispute between the parties. Interim measures such as evidence and property preservation measures will not only provide parties with an avenue to obtain access to justice in a timely manner, but will also secure the fruits of dispute resolution. As a result of the groundbreaking interim measures arrangement signed with the mainland in 2019, parties to arbitral proceedings seated in Hong Kong and administered by one of the 6 arbitral institutions would be able to apply to the mainland courts for interim measures. Such measures include property preservation, evidence preservation, and conduct preservation. Hong Kong is the first and only jurisdiction in the world outside of the mainland where this is possible. This arrangement no doubt increases Hong Kong's attractiveness as a seat of arbitration and also showcase our unique strengths under one country, two systems. To familiarize Hong Kong and mainland legal practitioners with the arrangement, the Department of Justice and the Supreme People's Court jointly organized a training session on 19th October 2019. And thanks to the support of the Supreme People's Court, the session was very well received and provided the arbitration community with practical insights on both the procedural and substantive issues in interim measures applications. On 17th August this year, the department also co-organized with CTEC Hong Kong Arbitration Center a webinar on the practical implementation of the arrangement, in which a judge from the Supreme People's Court and Hong Kong practitioners shared their updated views and knowledge on the topic. This event was again a great success and attracted approximately 800 online viewers, comprising legal and dispute resolution practitioners, as well as participants from the academic and business sectors. 2 years have passed since the arrangement came into operation on the 1st of October 2019, and as Sarah mentioned, I'm also very glad to hear that many practitioners have regarded the arrangement as a game changer, and the number of interim measures applications made to the mainland courts under the arrangement keep increasing. And as of 14th September 2021, the designated institutions have processed, according to my figures, 50, but according to Sarah, 54, we'll check that out in a moment, over 50 interim measures applications made to 23 mainland courts for the preservation of evidence, conduct, or assets worth 14.6 billion renminbi in total. From the information made available by HKIAC, 32 of those decisions have been issued by the Intermediate People's Court, amongst which 30 granted the applications for preservation of assets upon the applicant's provision of security, and 2 rejected the applications. The total value of assets preserved by those 30 decisions amounted to 10.9 billion renminbi. Looking forward, we will continue to listen to the views of the international arbitration community and see what we can do to further enhance the existing arrangement. I now turn to discuss the role of the Hong Kong judiciary in arbitration. An arbitration-friendly judiciary is one of the key factors that parties would consider when choosing the seat of arbitration. And Hong Kong's judiciary has all along been very supportive of the use of arbitration. Hong Kong courts have always strived to ensure that party autonomy is respected in line with procedural propriety. The pro-arbitration stance of Hong Kong courts has been consistently reflected in its case law. In a recent decision of C versus D, an issue arose as to whether failure to comply with the precondition to arbitration, that is, the requirement to attempt negotiations before arbitration, excludes the tribunal's jurisdiction or merely goes to the admissibility of the claim. In that case, the contract in issue stipulated that if a dispute arose between the parties, and I quote, the parties should attempt in good faith promptly to resolve such dispute by negotiation. The contract went on to say that either party may, by written notice to the other, have such disputes referred to the chief executive officers of the parties for resolution. And if any dispute could not be resolved amicably within 60 days of the date of the party's request in writing for such negotiation, such dispute shall be referred to arbitration. The plaintiff in that case contended that due to the failure by either party to give written notice to have the dispute referred to the CEOs of the parties for resolution, the tribunal lacked jurisdiction. The defendant, on the contrary, argued that the condition to arbitration was satisfied as it had given written request to negotiate by a letter to the chairman of the board of directors of the plaintiff, and it says, in any event, the question of whether the condition precedent had been fulfilled was a question of admissibility rather than jurisdiction. The Court of First Instance held that the non-compliance of the precondition to arbitration merely goes to admissibility of the claim. On the facts of the case, there was no indication that the parties intended compliance with the relevant provision to be a matter of jurisdiction. Notably, having gone through all the international authorities which suggested that non-compliance with procedural preconditions to arbitration merely goes to admissibility as opposed to jurisdiction, the judge concluded that this approach was, and I quote, entirely consistent with the policy in Hong Kong law, which respects the parties' autonomy in choosing arbitration as the means to resolve their disputes with its incident of speed and finality as well as privacy. Now, having said that, I must point out that this case is now under appeal, and we will no doubt revisit the issue when the appeal judgment is handed down. In today's conference, an interesting topic on cryptocurrency will be covered. In recent years, trading in cryptocurrencies in the virtual world has flourished. Disputes arising from these cryptocurrency transactions have created some novel and unique legal issues. In the context of resolving these crypto-related disputes in arbitration, two questions immediately come to mind. First, if trading and circulation of the relevant cryptocurrency is prohibited in the relevant jurisdiction under its national law, can we still arbitrate crypto-related disputes in that jurisdiction? Secondly, if the relevant cryptocurrency exchange has failed to comply with the local regulations, will it affect the legality or arbitrability of those transactions conducted over the exchange? In some jurisdictions, as mainland China, where redemption, trading, and circulation of virtual currencies are prohibited, there may be challenges to a crypto-related arbitral award. In 2018, the Shenzhen Intermediate People's Court, in a civil ruling, set aside an arbitral award compensating the claimant in US dollar equivalent of the Bitcoin amount, which was then converted into renminbi on the ground that awarding damages in US dollars in lieu of Bitcoin was against public interest. The reasoning of the Shenzhen court is that according to certain circular and announcement of the PRC, Bitcoin does not have the same legal status as a fiat currency and cannot and should not be circulated in the market as currency. Any so-called token financing and trading platform shall not, among other things, engage in exchange businesses between fiat currencies and tokens or between virtual currencies. As such, the arbitral award, which ordered damages in US dollars in lieu of the Bitcoin, amounted to redemption and trading between Bitcoin and fiat currency in a disguised form, which violated the public interest in the PRC, namely order and stability of the financial market. In Hong Kong, arbitrability of those crypto-related disputes probably would not be an issue. Trading in cryptocurrencies and other virtual assets is not prohibited here in Hong Kong, and indeed under Article 112 of the Basic Law, the free flow of capital is protected. Article 115 of the Basic Law further provides that Hong Kong shall pursue the policy of free trade and safeguard the free movement of goods, intangible assets, and capital. In addition, Hong Kong has a sophisticated and internationalized financial market, internationally aligned regulatory regimes, and strong rule of law. It is home to a large pool of financial and legal talents who are well equipped to handle complicated issues arising from the ever-evolving currency and financial market. In terms of the regulatory regime of the cryptocurrency industry, the government has proposed a new licensing regime under the Anti-Money Laundering and Counter-Terrorist Financing Ordinance for platforms which trade any type of crypto assets, even if they are classified as securities. Even if none are classified as securities. A very important change I have to make. Under the new proposal, if these trading platforms are registered in Hong Kong under the Companies Ordinance, they will be required to comply with the SFC, the Securities for Futures and Commission license. Given the risks associated with cryptocurrencies, in Hong Kong, it is proposed that these platforms can only provide services to professional investors. The new regime aims to ensure that the general public is well protected and at the same time ensure the healthy and orderly development of the crypto market, thus maintaining the stability of the financial market. It is also noteworthy that Hong Kong has an online dispute and deal-making platform, as we've seen how HKIAC has launched it, and there are other places which are providing such one-stop shop platform for commercial parties by which disputes can be resolved from all over the world. With these new developments and inherent strengths of Hong Kong as an international financial and dispute resolution center, we believe Hong Kong is well placed to resolve these crypto-related disputes as an arbitration venue. I'm sure the experts at the conference today will share more on the unique strengths of Hong Kong's dispute resolution services in this particular area. And note in the last session, Honorable Charles Brower will offer his views on tomorrow's arbitrator in this conference. I'm very excited to hear from such experienced arbitrator. I hope apart from core qualities of an arbitrator, we should always keep an open mind about the choice of arbitrators. Diversity and inclusion in terms of gender and ethnicity of arbitrators should be encouraged and promoted. This is indeed echoed by the EU diversity charters, which encourage organizations to promote diversity and equal opportunities in workplace, regardless of age, disability, gender, race, or ethnic origin, religion, or sexual orientation. Today's conference, entitled Tomorrow's Disputes Today, is very apt. Hong Kong is no doubt well equipped to resolve any future disputes, including those arising from the growth of digitalization or financial technology. And on this particular note, I only wish to conclude and say that happy anniversary to the Hong Kong Arbitration Week, and I wish this conference a great success. Thank you very much.
Thank you very much, Secretary for Justice. Now let's move on to the next session. This session will be about Hong Kong and PRC interim measures arrangements. I would like to welcome Yanhua Lin from Fangda Partners, Paul Starr from Kingwood Mallisons, James Rogers from Norton Rose Fulbright, and Sarah Grimmer from HKIAC. This session will be moderated by Freeman Yeo from Sidley Austin. Freeman is a partner at Sidley and also a member of our proceedings community. We are also very honored to have Dr. Yan-Li Se. Please put your headphones on because Dr. Se's speech is going to be in Chinese. And if you need a set of headphones, please raise your hands. One of my colleagues is going to assist you. With your headphones, press on and off for a few seconds and then choose English channel 01. So over to you, Freeman.
Thank you very much. Good afternoon, Honorable Secretary of Justice, Madam Teresa Cheng, and distinguished guests. Welcome to our first panel discussions this afternoon on the Hong Kong PRC interim measures arrangement. Now, the arrangement came into effect in 2019 and was touted as a game changer, giving Hong Kong a unique advantage over other arbitral seats for resolving China-related disputes. Now, 2 years on, and with the benefit of practical experience, real-life experience, we want to take stock this afternoon and consider how well the arrangement has worked in practice and whether it has achieved the success that everyone has been anticipating. And for that, I'm joined by a panel who can't be more qualified to comment on the topic. Now, the use of interim measures as a tool to facilitate arbitration proceedings and to safeguard the enforcement of arbitral awards has gained tremendous traction over the years. Parties to a Hong Kong arbitration can avail themselves to interim measures both from the court and the arbitral tribunal, and more recently, through the emergency arbitration procedures. The arrangement has provided a new option whereby parties can obtain interim or preservation measures directly from the mainland court. To recap, to take advantage of the arrangement, the parties' arbitration must be seated in Hong Kong and administered by one of the 6 eligible arbitral institutions that have an established presence in Hong Kong, including the HKIC, of course. And so this is a marked departure by the PRC courts, which do not typically issue interim measures in support of litigation or arbitration outside of mainland China, nor do they readily enforce interim measures issued by foreign courts or tribunals. Before we get into our panel discussion this afternoon, we have the pleasure of hearing from our keynote speaker, Dr. Si Yanli, regarding the history and implementation of the arrangement. Dr. Si has been heavily involved in the drafting of the SPC's note on the interpretation and application of the interim measures arrangement. And the note provides guidance to applicants when navigating the application process before the PRC courts and should be considered alongside the provisions of the arrangement itself. Dr. Si will deliver her speech in Mandarin, and so allow me to introduce her briefly in her native tongue.
今天下午，我们非常荣幸邀请到最高人民法院研究室副主任施艳丽博士，就内地与香港两地关于仲裁程序互相协助保全的安排做主题演讲。施艳丽博士一直不遗余力地推动内地与港澳特区民商事司法协助安排的方面的进展。施博士也是最高院发布的仲裁保全安排的理解与适用的撰写员之一，因此由他来介绍为我们接下来的讨论揭开序幕最恰当不过。我们下面有请施艳丽博士，谢谢。
尊敬的张举能首席法官、郑若骅司长、各位嘉宾，大家下午好。首先祝贺2021年第10届香港仲裁周开幕，很高兴参加今天的亚洲替代性争议解决大会。应主办方的邀请，我想和大家谈谈内地与香港仲裁保全协助安排在内地实施2周年的情况。刚才严冠华先生已系统介绍了这项安排的主要内容。下面呢，我想从这项安排的参与者、推动者和见证者的角度来谈谈我的体会以及这项安排的实施情况。首先，我想说的是，内地与香港仲裁保全协助安排是一国两制方针在司法法律领域的贯彻落实，是两地法律人实践一国两制的重要举措。正是因为一国在两地仲裁保全制度存在显著差异的情况下，内地法院可以采取保全措施，以支持香港的仲裁程序，从而使这项安排成为内地首个向其他法域的仲裁程序提供保全协助的文件。也正是因为一国，内地与香港在仲裁领域的保全协助实现了全面的覆盖，包括仲裁程序开始前、仲裁程序进行中、受理认可和执行仲裁裁决的申请之前或者之后等，标志着内地首次与其他法域建立起完备的仲裁保全协助。正是因为两制，内地与香港有开展司法协助的必要，也正是因为两制，内地与香港磋商司法协助安排时，双方解放思想，平等协商，求同存异，努力寻求两地法律的最大公约数。比如，对于两地法律概念不统一的，采取分别表述的方式处理；再比如，对于两地法律规则不一致的，采取创新表述，实现有效衔接。总之自香港回归祖国以来， 内地与香港签署的一系列司法协助安排，其协助的力度、深度、广度远远超过国际公约和国家间的条约，实现了一国之内更加紧密的合作，也充分彰显了一国两制是香港最大的优势，亦是香港营商环境的最大优势。接下来我想谈谈这项安排在内地法院实施2周年的情况。截止2021年10月22日，内地法院共受理了54起仲裁保全申请。下面呢，我就想详细为大家介绍一下这54个案件的情况。第一，从保全类型来看，在这54起申请中，51起为财产保全申请，2起为证据保全申请，1起为行为保全申请。其中呢，财产保全申请总金额达到了23亿美元。第二，从仲裁案件的情况看，这54起申请所涉及的仲裁程序均是以香港为仲裁地，并且由香港国际仲裁中心管理。仲裁案件争议类别涉及到商业、公司、金融、海事、货物买卖以及专业服务领域等。第三，从当事人的身份看，保全申请人中约有23%来自内地，约77%来自境外，比如说像香港瑞士新加坡等等被申请人中呢，约有58%来自内地，约有呢42%来自境外，比如说像香港、荷兰法国等等。那么第四，从保全申请的阶段看，所有申请均为当事人单方申请，并且呢是于仲裁程序启动之后提出的。目前为止呢，香港仲裁程序的当事人尚未向内地法院提出仲裁前的保全申请。第五，从保全担保的形式看，当事人在提出保全申请时，几乎均向受理法院提供了相应的担保，并且呢，担保的形式大都是灵活便捷的保函。第六，从保全申请的处理情况看，上述54起保全申请共向内地的20个城市，涉及到24个中级人民法院，其中法院已处理完毕37起申请。在这37起申请中其中呢有34起被法院裁定支持，3起呢被驳回，保全的资产总价值呢约合18亿美元。那么对于上述案件办理的时间呢，经过初步统计，从法院收到保全申请到最终作出裁定，平均用时呢是19天。最快的在收到保全申请的当天即做出了保全裁定。那么从以上数据我们可以看出，内地法院呢是高度重视涉港案件的审理，执行仲裁保全协助安排的总体情况良好。最后我想谈谈内地法院未来与香港紧密协作的一些设想。大家知道，目前粤港澳大湾区国家战略正在顺利推进，如何充分发挥一国两制三法域的独特优势，建立共商、共建、共享的多元纠纷解决机制，是摆在我们面前的重要课题。为此我们在考虑以内地与港澳现有的司法协助安排为基础，研究探讨在相关领域推进粤港澳之间更加紧密的合作，以实现粤港澳大湾区法律规则衔接的新突破。再比如说呢，利用粤港澳大湾区先行先试的政策优势，探讨在没有涉外因素的情况下， 当事人选择适用香港法律以及选择香港作为仲裁地的可行性，也就是大家目前热议的港资、港法、港仲裁。还比如呢，为提高司法协助效率，努力推进司法与科技的深度融合，我们也在尝试在内地与香港之间建立司法协助网络平台，两地法院可以相互委托送达文书和调取证据，以实现在线的转递、在线的审查、在线的办理和在线的追踪等等。实践证明啊，只要有利于保持香港长期的繁荣稳定，有利于增进香港同胞的切身福祉，有利于内地与香港的融合发展，内地人民法院都会坚定的支持。以上是我向大家介绍的内容，谢谢大家。
Thank you, Dr. Si, for that overview. Some very encouraging news there. For the panel discussions, let me quickly introduce our panelists again. Joining us virtually, we have Ms. Lin Yanhua, who is a dispute resolution partner at Fangda Partners based in Beijing. Joining us from London, Mr. James Rogers, arbitration partner at Norton Rose Fulbright. And here, live at the HKIC, joining me are Ms. Sarah Grimmer, who needs no further introduction, and Mr. Paul Starr, King & Wood, Mallison's partner and practice leader of the firm's construction and dispute resolution group in Hong Kong. First of all, congratulations to the HKIC. We have heard all 54 applications relate to cases administered by the HKIC. That's a tremendous record. Sarah, if you could perhaps start us off by telling us what is the HKIC's role in the process and what's the institutional take on how the arrangement has worked so far?
Thanks, Pravin. So the role of the institution is to issue a letter to confirm that the arbitration is being administered or has been accepted for administration by the institution. That being one of the conditions to make an application under the arrangement, the other being that Hong Kong is the seat of the arbitration. So we receive requests of this nature. We try to, we issue letters of confirmation within 24 hours and we don't charge a fee for that, but we do perform a prima facie scrutiny of the case to make sure that it is a case that is administered by us. When I say administered by HKIC, I don't mean just under our administered arbitration rules, but also under, for example, the UNCI-trial arbitration rules. We administer cases under those rules, and we have had 2 cases under the UNCI-trial arbitration rules that we've administered that have gone for interim relief in the mainland. So we perform a scrutiny in terms of the seat and administration, and then we assist with whatever steps need to be taken then in respect of the court, and I can come on to that if you'd like.
Sure. Now, we've heard that all the cases involve preservation or application for preservation measures after the commencement of the arbitration. And I think that's the process that you've described. But if, I believe there's an option for pre-action preservation measures. Would the process be very different from the parties or the HKIC's perspective in terms of
No, it would be
works?
straightforward. So in that situation, a party can apply to a mainland Chinese court for interim relief before it commences the arbitration. My understanding is that is more challenging to have a successful application than if you have commenced an arbitration. So perhaps that explains why we haven't seen any yet. In that case, what a party needs to do is if they have a preservation order, then they come to us within 30 days and ask for our letter confirming that we administer, and we will issue that once the arbitration has commenced. So they would need to commence the arbitration within 30 days of obtaining the interim relief. Otherwise, the interim relief will be discharged.
And what is the, is there communication between the HKIC and the courts themselves, or is that through the parties? How does it actually work?
Yeah, so we have seen in some of our applications that we will be asked to verify information in a case by the court. And that request can come to us in two different ways, really. Either it can come to us through the applying party, the applicant, or we can receive such a request directly from the court. And that will come to us typically to the case manager, because those contact details are provided in our letter of acceptance. So the court will email us or call us directly to confirm information. The kinds of requests we get are to confirm, for example, the amount in dispute, what date the case commenced on, the identity of the parties. We have had a request to confirm whether or not a party has made an application for preservation in another application. And our position is that if we can answer a request for information, we will do that, but we're not always in that position. So we may issue a qualified confirmation of information, but that's how the information comes to us. And one observation I will share is that over last year and this year, we have received fewer such requests. And I think that's because the courts are much more familiar, and in particular, some of the courts that have seen repeated applications, so Shanghai, Beijing, some of those intermediate people's courts, some of the divisions there, and Shenzhen, for example. So we're seeing fewer such information requests than we did in the early months.
Excellent. That's very helpful. Perhaps I would turn to Yanhua, obviously an experienced practitioner based in the PRC, and I understand has had much experience in this area. What is the process like from a practitioner's point of view? What standards do the PRC courts apply?
Thanks, Raymond. In the PRC court, the application process itself is relatively straightforward. So the parties should make an application either to the Intermediate People's Court of the place where the respondent's residence is located or where their assets are actually located. And the PRC court is required to render a decision within 5 days upon the acceptance of the application, or within 5 days after the security is provided, if the court requires security to be provided. And usually, the PRC court would order security to be provided. But as our guest just mentioned, the more frequent use option is to purchase liability insurance products for asset preservation, which are offered by all the major qualified PRC insurance companies. The parties need to pay relatively low percentage insurance fees. I think it's something around 0.5% or even lower of the disputed amount or the preserved amount. So after you pay the insurance fee, the PRC insurance company would be able to issue a guarantee letter to the court. Usually, after the court receives the insurance company's guarantee letter, the court would issue a preservation order. And generally speaking, this is different from Hong Kong standard. The PRC court actually adopt, I would say, it's a broad brush approach in determining preservation application. So they would normally grant the application so long as the applicant provides security. They are usually quite flexible on the standard of serious issue to be trial or the balance of convenience. Although certain courts may require an applicant to explain, such as the urgency of the circumstance or why the applicant may suffer harm if the application is not granted. But usually if we face such request from the court, we would make a written submission to the court to do some explanation, and usually the court would still grant the application. And in our actual experience, the timing from submission of application until the court granting the application range from 1 or 2 weeks. And I would say that I totally agree with what Sarah just mentioned. So in the first year, in 2019, at the beginning of this arrangement, it took us more time and effort to try to expand to the PRC court, because this would be the first case how the partner, also the council, the inquiry for the how the parties to the PC question. So questions this year, and it also feel that time for the court to grant the preservation orders is much less than last year. So I think in a recent case, it only took us 1 week to obtain the preservation order.
I see. Thank you, Yanhua, for that overview. I know that Paul and James also have had experience with an application under the arrangement. What are your experience in this regard? Any practical tips that you might have to offer? Perhaps I might just start off with James.
I think the most important consideration is to engage good local Chinese counsel. For all the reasons that Yanhua has just explained, they are so close to the process, and answering those questions that the local courts might have, verifying documents, that is the most important part of the process. And I can certainly vouch for Yanhua in that respect. The case we recently handled together went very, very smoothly, in large part because of all of the early preparation and coordination work that she undertook. Really, from my perspective, there wasn't much for me to do. I would say the one administrative aspect that clients may not think about is the need to get documents translated and notarized ahead of time. And this can be a problem in different jurisdictions. The place of notarization, the particular embassy involved may have different requirements. The local court in question may have different requirements. So there can be some back and forth about that. It doesn't seem to the client a particularly important consideration, but trust me, it can take time and delay things if it's not done properly. We've seen that not just in this context, but also in applications to enforce awards in China, for example.
Thank you. Paul?
Well, of course, I entirely agree with James, and I've got to put in a plug that we, together with our Beijing and Shanghai offices, were the first firm to, with HKIC's help, obtain a $400 million asset protection from the Shanghai Financial Court. And I think choosing the right court, as James says, working out what they require is absolutely essential. The biggest difference I found as a common lawyer between what we do here and for example, in England and what they do in the China mainland is what's called asset clues. And what we found in this particular court required us in advance to actually work out what assets the company had. We had to give clues to the court as to the assets that were being held. And for that, and if you're doing a timeline for it, and I think that's probably the thing that takes the longest, because for that you had to hire private investigators. And in China mainland, some can actually find bank account details, which will shock common lawyers here in the room. But we managed to find bank account details, real estate details, even details of vehicles, subsidiaries, holdings. And there are some public records, but not that many. So I think that's the longest thing. Then in terms of time, of course, translations and notarizations, as James has said, we had to do it during COVID. All the embassies were closed. All the notary publics were closed. So we had to use our guanxi to obtain that from them. But I think that's a very important area as well. Security has already been mentioned. Getting that done, that takes a long time as well. And early liaison with HKIC. I think we came along and saw you and sort of told you what we were planning to do, and you were very helpful telling us what to do. And I think to remember also, it sounds a bit obvious, but remember the application is ex parte. You're going on your own. Now, in a common law situation, if you get the order, you then serve it on the other side. You don't have to do that in China mainland. The court does it for you. So you hope they take a nice long time to go and actually find the assets. The court will help you to actually preserve the assets. The judge in our case traveled to the local branches, local court branches, actually to help us freeze some of the subsidiaries' assets. And at the same time, hopefully slowly, they serve the order on the other side. So that's another great tip, to not sort of rush off and serve the order.
Right. Yeah, certainly very helpful tips for those who have yet to have that experience and looking to do that. Just want to just slightly switch gear. We have heard from the statistics, which I found really interesting, about in relation to the identity of the parties that Dr. Si had mentioned. And I found it particularly striking that 42% of respondents, I think she said, are from non-mainland background. Has that surprised us? Perhaps, Sarah, what's your take on this?
Well, I think it was perhaps a surprise. I don't know what I expected, but it's something we watched very closely, because I think, you know, when this first came into place, one of the comments we sometimes heard was, oh, will this mean that mainland Chinese parties will not want to choose Hong Kong because it makes them vulnerable to interim relief in a way that they're not if they choose another seat, not including onshore arbitration. And then what we saw come out of the cases was that it's of benefit to mainland Chinese parties. So you would have heard that the applicants, 23%, so a good 1/4 of the applicants are mainland Chinese parties. And then the respondents, you know, it's 58 to 42%. So that's a pretty, it's not too much of an uneven split, but a lot of the respondent parties are foreign parties with assets on the mainland. So I think that that has been a really interesting shakeout of how the arrangement is being used.
Indeed. Yes, and I think that's a good testament to the fact that the arrangement, I think, benefits all parties and not just foreign parties. Perhaps Yanhua, have you? What is your take on this? Have you seen that the arrangement may have had any effect of disincentivizing Chinese parties from choosing Hong Kong as a seat?
I think we have rarely seen a Chinese party refusing to choose Hong Kong as a arbitration seat, solely because of the arrangement. Because I think to most of the Chinese parties, the choice is Hong Kong versus mainland as arbitration seat. And therefore, the arrangement little bearing on that choice because the attraction that Hong Kong can offer are still intact. For example, the mixed culture background of Hong Kong, the highly professional nature of the arbitration institution in Hong Kong, such as HKIC, the pro-arbitration stance of Hong Kong court, and also the fact that that there is a significant number of reputable bilingual arbitration practitioners, in particular arbitrators, are based in Hong Kong.
I see. What about from the international client's perspective and Hong Kong client's perspective? Do clients, we've talked about the arrangement as a potential game changer. Do clients actually consider the availability of interim measures under the arrangement as a key or decisive factor in whether or not to choose Hong Kong as a seat of arbitration? Paul?
Well, I think we as practitioners have got to be better at educating clients, if I can put it like that. I think other jurisdictions in Asia have done a better job in the past at educating clients as to the advantages of their particular jurisdiction. I think now in Hong Kong, we're doing an awful lot more at really going out there and trying to explain the advantages. But I've always thought, Friven, that if you're doing business with mainland Chinese parties, whether you're a mainland party yourself or a foreign party, you would be insane not to choose Hong Kong. because you haven't just got this benefit, you've got all the other benefits that have been outlined, including, of course, the new pilot scheme for liquidators to go into the mainland now. So you'd be absolutely nuts not to choose Hong Kong in that situation, but it's a question of telling clients that. What's Sarah?
No, I think my answer to your question would be well-counseled clients definitely find this important. We know of cases where if the arbitration if they had not managed to obtain the interim relief on the mainland, the arbitration would not have continued. So in 2 cases. So that's pivotal. And you know, what are you concerned with arbitration? You're concerned with enforcement. And interim relief is connected to enforcement, and it ensures it. So it's a no-brainer. Yeah.
What's your take, James?
I would agree. And I would agree with Paul's language as well. I think you'd be absolutely nuts if you're involved in a transaction with the Chinese party not to choose Hong Kong. But look, sometimes I think we overestimate the sophistication of clients. Not all clients are so sophisticated that they're thinking about the arrangement or interim measures when they are agreeing their arbitration agreements. Some clients are. We recently had a case for a big international oil company, and now that they know about the arrangement, now that they've seen the arrangement work, they've said, well, we must have Hong Kong HKIOC for all of our China-related contracts. But that wasn't the case until 3 or 4 months ago. So we must absolutely continue to do all we can to educate clients, the market about the arrangement, about the benefits of Hong Kong as a important or the only real choice for arbitration with Chinese parties. And it goes beyond that, of course. Hong Kong, looking into Hong Kong now as I do from London, Hong Kong, it's fair to say, has had some bad press over the last couple of years. And we're regularly asked questions like, is Hong Kong an independent jurisdiction? Is the judiciary independent? Is it a safe place to arbitrate? And clients tend to look at things at a high level like that. It's very much about perception. And so I always answer emphatically, yes, it is, and does remain an independent and a great place to arbitrate, and particularly when you're dealing with Chinese parties. But that is an ongoing battle that we must continue to educate the market on.
Friven, we've all experienced these stories of you ask your client, oh, you chose New York law and arbitration in London. Oh, we just pulled this dispute resolution clause down from a precedent. We didn't have time at tender to look at the dispute resolution clause at all. And I mean, it's just a nightmare. But that's, I'm sure everyone in the room has experienced something like that.
Absolutely. Yes. And to James's point, I think the proof in the pudding is in the eating. Hong Kong remains a highly favored seat, and I think we would all be doing our clients a disservice by just pulling clauses and without really considering, giving this a very considered view. Why Hong Kong or why not Hong Kong? Yan-Hua touched on the broad brush standards I think that the PRC courts adopt in considering the application. I think for the benefit of some of our audience who may not have come from a common law background, perhaps I might ask James to maybe take us through, from a common law perspective, what are the standards? Is there a difference in terms of the standards, and how would you how would you advise your clients as to which route to take?
Well, at least as I understand the standards, they are different. And in China, the bar to succeeding on an interim injunction application is lower. In a common law jurisdiction, such as Hong Kong or London, where I now practice, you do need to show a likelihood of success on the merits, a real risk of dissipation and urgency, and you also need to demonstrate that the risk couldn't otherwise be compensated by damages. So that means there's a number of hurdles that you have to overcome to get to succeed on any interim measures application. And so given that higher hurdle, that favours proceeding in China. And of course, if that's where the assets are, it makes sense to do it in China as well. But it is very much horses for courses. That there will be reasons why you might nonetheless proceed in the Hong Kong courts or before an emergency arbitrator, particularly if there's multiple jurisdictions involved, multiple parties involved, assets in different jurisdictions, etc. Sorry, there's someone speaking in my ear, I'm not sure. And the other thing, emergency arbitration in particular, it's a very, very flexible tool. It can be used in many different ways, and we've seen that over the years as very different types of applications are made. And sometimes it's not necessarily about preserving assets or preserving evidence or what have you. It's almost a proxy battle to have an early decision on a key issue resolved by an arbitrator, which, while that can be reopened by a subsequent tribunal, will carry weight through the arbitration. So look, there's obvious reasons why you would go to China and use the arrangement, but as I said, it's very much horses for courses, and those other avenues, the Hong Kong courts, or indeed other courts anywhere around the world, or proceeding before an emergency arbitrator, are all important options.
Paul, in light of the different standards that we've seen, do you think there's any sort of tactical issues in whether you would advise your clients to go the PRC route or through the Hong Kong courts or tribunal route? Is there any scope for abuse in that system?
Well, I think, as James rightly says, it really depends where the assets are. I mean, that's an obvious point. You've really got to study very carefully whether it's worth going to China mainland, or if, indeed, as James was saying, sometimes the assets may be predominantly here in Hong Kong. And I wouldn't be too frightened about going to Hong Kong courts. I mean, those of us in the room here, most of us have either obtained injunctions on occasions or not. I mean, it depends on the merits of the case, but certainly we've been quite successful, I'm sure most of us, in obtaining very significant injunctions from the Hong Kong courts. So not to be overwhelmed by that. In terms of the tactics of emergency arbitration, I think you have to bear in mind, first of all, there's the big debating point about whether you can go ex parte to an emergency arbitrator. I've been to many seminars and conferences about that, but I think the favoured view at the moment is that you be a very brave emergency arbitrator to hear a matter ex parte when arbitration is consensual and the parties have agreed to this procedure. I'm not entirely sure whether an emergency arbitrator would hear the matter ex parte, so you've lost the element of surprise. Then, of course, his or her decision can get overtaken by the full tribunal when appointed. So you haven't got that certainty. And then, of course, you might have enforcement problems. So I think on balance, as James was saying, if you can go to China mainland, there may be very good tactical reasons why you would want to do that. There are some disadvantages for him. I can think of two examples that we've had recently. One where the judge said, my roster's a bit full, so come back next term, next semester, and I'll hear it then. And that actually happened. And another where basically the court was very nervous to actually grant emergency relief until after we actually got the arbitration award, which has now happened. And so obviously, just like in any court, it's not guaranteed that you're going to get a result in China mainland. But I think on balance, tactically, if the assets are there, it was very worthwhile having a go.
Excellent. You would hope those sorts of problems, Paul, will improve or have improved now that the arrangement has been used much more in the mainland. I know the Chinese system has been very good over the last couple of decades at improving its systems and weeding out those sort of problems. So I hope that those are anomalies.
Indeed. Maybe my next question is to Yanhua. We have heard that the applications to the courts are on an ex parte basis. How do the courts in China protect parties against interim measures that are wrongfully sought? Is there room for appeal or seek a discharge of the measures?
I think because that's why usually the court will require the applicant to provide security. And the point for providing the security is actually potentially to compensate the other party if such preservation is required. I have to say that this decision of granting preservation from the PRC court is not subject to appeal. In that, after the decision is made by the Intermediate People's Court, it becomes enforceable. Although legally speaking, a party may apply for reconsideration of that decision. The reconsideration application itself would not stop the performance of the decision. In practice, it's quite difficult to challenge preservation order granted by the PRC court, unless in a relatively extreme cases where the asset preserved actually belong to a third party. And when the third party apply to the court for reconsideration, and the third party can actually prove that the asset actually belong to them, the asset preservation orders could be discharged in that case.
I see. That's very helpful assurance, I think, to the parties. I think turning on and moving forward, we have heard this morning about, we've had a separate session on the draft amendments to the PRC arbitration law. Do you think that would have any impact on the arrangement insofar as it relates to expanded options to seek interim measures, for example, through the arbitral tribunals? Perhaps I might ask Yanhua for her views and the views of other panelists as well.
Sure, Freeman. I think in the current draft of the PRC amended arbitration law, I think deal with the case where the parties may apply to tribunal in domestic arbitration, the mainland domestic arbitration for interim measures. As we all know that under the current PRC arbitration law, if parties in domestic arbitration may want to apply for asset preservation, if the application actually go to the PRC court, right? And the amendment actually allow the party to apply to the domestic arbitral tribunal for granting interim measures. But the current draft actually has not dealt with the issue of whether the interim measures by Hong Kong Arbitral Tribunal or Foreign Arbitral Tribunal could be enforced in mainland China. So I think at this point, it seems that the amendment, the draft amendment have no impact on the arrangement itself. And in my view, even if the draft amendment in the future will allow interim measures ordered by Hong Kong or Foreign Arbitral Tribunal to be recognized and enforced directly in the mainland China, I think both mechanisms will have advantage and disadvantage in different types of cases. For example, applications for asset preservation under the arrangement are now conducted on an ex parte basis. But an application made to the arbitral tribunal usually should be conducted on an inter-party basis. So I think both mechanisms may offer pros and cons to different types of cases. So overall, I think the draft amendment to the PRC arbitration law provide additional options for the parties, and they are unlikely to cause significant impact to the arrangement itself.
Other panelists, and any views in that regard? Then perhaps a slightly different topic then. We have heard that there was one case on conduct preservation. I mean, in the context of interim measures in the mainland, we know a lot about evidence preservation and asset preservation. But what is conduct preservation? Yanhua, is that something akin to what we know as injunctive relief or something else?
Yes, I think conduct preservation under the PRC law is similar to injunctive order in the common law system. So meaning that this is an order requiring the party to do certain action or not to take certain action. So this is what we mean by preservation of conduct.
I see. And understand that there was one application on conduct preservation that the HKIC has dealt with. Sarah, what was our experience in that regard?
Well, it was interesting. The application was filed as a preservation for conduct case. It was filed by the applicant with respect to a third party to the arbitration. So what was happening was that the applicant was filing for the preservation of conduct. The applicant had provided professional services with respect to acquiring insolvency claims against a third party in respect of a trust in mainland China. And the conduct application, preservation application, was with respect to the trust to stop the trust from allocating assets to the respondent. So conduct preservation in respect of a third party to the arbitration. And the court treated it, well, the court's decision was actually a preservation over the assets of the respondent. So notwithstanding that the application had been made vis-a-vis a third party to the arbitration with respect to that party's conduct, the decision was a preservation over assets of the respondent in the arbitration. So that's the one application where we've seen preservation over conduct applied for, right. But dealt with as a preservation over assets by the court.
I've got a lovely one, Friven.
Excellent.
A conduct preservation. Yeah. It's because it started at Chinese New Year, about pre-COVID, about 2 years ago. I was going on something you won't remember called a holiday. And the day before Chinese New Year, the client rang me up. Oh, Paul, they're going to remove me as director and all my nominees and all this sort of stuff. So what we did with HKIC's help, we began on Chinese New Year's Eve day, an emergency arbitration. We tipped off the HKIC as was happening. Firstly, an emergency arbitration in Hong Kong to try and stop my client being removed and his nominees as director. And we were successful in that emergency arbitration. Now, as I've said, emergency arbitration then can get overturned in whole or in part by the full tribunal. I'm looking quickly to see if the full tribunal is in the room, but it doesn't really matter because they part overturned the emergency arbitrator's decision. And they decided as a matter of law, PRC law, that removal of directorships should be handled by the PRC courts. So we then had to trundle straight off to the PRC courts to litigate that as an urgent conduct preservation matter to get that preserved. And we were successful in that as well. So that was an interesting one.
Excellent. Any other experience on conduct preservation, and when would you expect a party to apply for one? Is it limited to certain types of cases, like intellectual property? I think I've heard quite a few measures, interim measures being applied in connection with intellectual property disputes. But is it so limited, or are we looking at perhaps a broader range of cases as possibilities?
Freeman, I mean, under the PRC law, I mean, technically speaking, conduct preservation is not limited to a certain type of dispute. It is just that in practice, however, conduct preservation is more commonly seen in IP-related litigation, and it's less commonly seen in what we call ordinary commercial disputes. I think the court, when they review this preservation application under the arrangement, I think the PRC court in practice follow the same standard as they treated cases, the application from domestic arbitration. So it would be still more difficult for the party to obtain conduct preservation from PRC court under the arrangement. But we do hope that the PRC court will become more flexible in this regard, because the law actually, if not encouraged, but actually they perfectly allow the parties to apply for conduct preservation. And actually, in domestic cases, we have been succeed in obtaining certain types of conduct preservation in non-IP cases.
I see. I think we have a few minutes for questions. So if there are any questions, you're most welcome to submit your questions online, and I will get to see these questions and get them answered. One question that has come through, and perhaps this is more for Yanhua. For the security, I hear that the applicant may pay to an insurance company 0.5% of the disputed sum.
0.5.
0.5% of the disputed sum. Question is to the panelists: do they have experience as to any insurance company having to pay up full security, and how that works?
Not in my experience.
Any thoughts on the issue of security and how much is being asked and how we practically deal with it?
Well, I'll put in a plug for my client Ping An very quickly, because on my big one, they were the ones that granted the policy. Let me tell you how it worked, Friven, because I happen to have thought you might ask that at some stage, or someone in the audience might. Firstly, the policyholder and the insured is the asset preservation applicant, of course. The insured amount is the same amount that you're trying to preserve. So in my case, it would have been approximately $400 million US. I think it's 0.5% that you're looking at, not 5%, I believe. It's Yanhua will be able to, yeah.
0.5.
You're correct, that's what I think. I agree. And what it guarantees is financial losses which may be suffered by the respondent or third parties where the applicant has incorrectly applied for asset preservation. You give the insurer the details of the respondent in the case, including the asset clues that I mentioned, and also various other, obviously, things that they requisition, bits of information they ask you. Now, we were told this at the time by our Shanghai office. The actual liability of the insurer is joint with the applicant. So you as an applicant shouldn't forget that. The applicant won't be immune from that. However, in answer to your question now, the PRC court usually sets a very high standard of proof for the respondent if it wishes later to allege improper asset preservation. And normally, only in cases where the value of preserved assets is far beyond the claimed amount, or the application is maliciously filed based on a fictitious claim, may the court uphold the compensation. But we were given statistics, obviously it's only 2 years in at the moment, but obviously statistics also from domestic cases. It is quite difficult and statistically to persuade a court to call on this security. As I think it probably is in Hong Kong. I don't know what other practitioners in the audience think, but I think it's quite difficult here as well, Friven, to do that. It's a heavy burden for the...
I was going to say the same thing, Paul. Applicants in common law jurisdictions have to give commitments as to security as well. And I can't think of any example in my career where that's been called against.
And Friven, just with respect to protecting the respondent's interests, we have seen a case, one of our cases, where the original decision of the court was with respect to a certain number, or a certain amount, and then an application was made back to the court to lower that amount because the original decision had not taken into account the fact that the applicant held shares, a certain number of shares. It was a put option dispute. And so the court was willing to adjust down the amount of the interim relief, the preservation order over assets in that respect.
I see. Great. One other question that has come in. If a conduct preservation order is granted at the PRC court, what is the sanction against the ordered party for breaching the order? Perhaps also
Technically,
Yan-Hua.
technically speaking, it would be subject to a fine, or even in the most serious case, some criminal liabilities if the respondent breach the order. But I think the more immediate consequence for a party to breach a conduct preservation order is they would lose credit, and they are likely to lose the case on merits first. So it actually press a lot of pressures on the respondents if they are subject to a conduct preservation order.
I think that's right, Friven. And you might ask yourself psychologically, why do people comply with these asset preservation orders and with emergency arbitrator orders? And it's because, as Yan-Hua says, you're looking at the ultimate tribunal. The tribunal is going to say to you, when the tribunal gets appointed, well, why haven't you done this? Have you removed the director, or have you preserved the director's position? Have you complied with this particular aspect? So I think a respondent's not going to take part in the arbitration. It's going to be naughty and not participate. I could see that they might breach and then suffer the consequences that Yan-Hua says. But somebody that's actually going to face the full tribunal eventually, psychologically, needs to think very seriously about not complying with these sort of orders.
Yes, that's right. And sometimes, I get the clients asking, oh, well, you can't enforce it in China anyway, an emergency arbitrators orders. But I think the psychology of that is directed at the respondent is sometimes underestimated. It's very helpful tips. We're coming to the tail end of our panel. So 2 years on, interim measures arrangement. We said it was a game changer, and it looks like with the benefit of 2 years of experience, it does seem that it's taken advantage of, and we have got a lot of practical experience in applications through the arrangement. Any sort of final comments on where you think this will lead? What is the outlook for the arrangement? Any final thoughts from our panelists? Perhaps I'll start off with James.
Look, I think the arrangement, I think someone used the phrase game changer. I think it's a great tool, and it's fantastic for Hong Kong as a venue for arbitration. And I just think it's going to compel parties to use the HKAC and Hong Kong arbitration.
Yan-Hua?
I totally agree. This is a game changer. I think it helped the parties and also the councils a lot. I think Hong Kong would become much more attractive as a seat of arbitration upon the effectiveness of this arrangement.
Paul?
Well, post-COVID, we will travel again, Friven. The Belt and Road will revive again. The GBA will become even more significant to Hong Kong. And when I last paid a trip to a government and they said, let them arbitrate here, by which they meant let investors come to their country and arbitrate, they did not understand the benefits that Hong Kong, the unique benefits that Hong Kong could bring by this type of asset preservation to their own citizens, to their own investors. So the more people realize that, the more business they do with this part of the world via the Belt and Road, the GBA and other initiatives, the more they will suddenly realize the unique benefits of Hong Kong, as I've said, not just in terms of asset preservation, but I'm also very excited about this new pilot scheme for liquidators in enforcement measures in the mainland.
Institutional take?
I would say game changer, no-brainer, rainmaker for Hong Kong.
I enjoyed Paul's comment. You'd have to be nuts not to use Hong Kong.
Right.
And for me, it's really struck me how seamless the whole process has been. And sometimes we think about, oh no, having to go through bureaucracy after bureaucracy to get what you need. But we've seen how quickly the process has gone, and how it has really benefited the parties in terms of the amounts that have been preserved, amongst other things. So I certainly agree with the sentiments of the panelists. Game changer, no-brainer, rainmaker. With that, I want to thank my panelists for their very insightful comments and contributions this afternoon. Thank you very much.
Thank you.
Thank you very much for this informative discussion. Now we are going to give a little break to our legal discussions and welcome Suraj Sajnani and Kitty Jeng, who are both members of HK45 and will announce HK45 essay competition winners. Suraj, Kitty, the floor is yours.
Thank you. Good afternoon, everyone. My name is Suraj Sajnani, and joining me here is Kitty Zeng. Both of us are members of the HK45 committee. For those of you who do not know, HK45 is the HKIAC's young practitioner group for people interested in arbitration in Asia and beyond. Although the name is HK45, you do not need to be in Hong Kong, nor do you need to be under the age of 45 to join. We welcome the young as well as the young at heart. HK45's key engagement with its members is through events. This year, we've hosted fireside chats with a diverse range of eminent practitioners, co-hosted a cross-examination workshop, provided numerous writing opportunities, and tomorrow we'll be hosting our annual pub quiz in trend-setting hybrid format. Personally, I've been a member since I was a trainee, and through the years, it's been an absolutely wonderful platform through which to build relationships with young members of our little community. So I encourage young practitioners to join by going to the link that's on the slide. With that, I'll hand over to Kitty to tell you a bit about our inaugural essay competition, and then we'll announce the winners.
Thank you, Suraj. For our inaugural essay competition, we invited young practitioners and students from all over the world to submit essays on one of the 3 topics that are shown on the screen here. These topics deal with a range of timely issues impacting arbitration today, including artificial intelligence, climate change, COVID-19, and technology. We were very excited to have received submissions from 13 different countries, both in Asia and beyond. These essays were then grouped into 2 categories, an emerging economies category and a global category. Suraj and I read virtually every essay, so we can personally attest to the fact that the quality of the essays that we have received was extremely high. This, of course, makes our job much harder to pick the winners. But following 2 rounds of scoring, first by our committee members, and then by our esteemed panel of judges who are shown on the screen here, we were able to identify a few essays that truly stood out from the rest. And we are very honored today to have 2 of our judges, Ms. Qian Bao and Mr. Neil Kaplan, to announce the winners. These winners will then be awarded various cash and book prizes valued as much as 14,000 Hong Kong dollars. Now, without further ado, may I first invite Qian to announce the winners in the emerging economies category. Qian.
Thank you very much, Kitty, and it's a pleasure to be here with you virtually. And it's such a great set of categories, and I'm so pleased to be able to announce the emerging economies category winners. As Kitty has said, the quality of the essays have been truly exceptional. And the first round of prizes go to honorable mentions in the emerging economies category. The essays that made it into this category were persuasive, well-researched, and well-articulated. And the award goes to Maruf Rafiq from Pakistan, Helen Sababal from Lebanon, and Namrata Shah from India.
Round of applause.
Congratulations, everyone. The participants are all on video and able to see us, but unfortunately, we are not able to see them. For all of you listening, congratulations. And now the second runner-up prize goes to Sidesh Barajar from India. Sidesh's essay did a terrific job of proposing a way for states to use ADR, in particular mediation, to actively engage in dialogue to resolve climate change problems that we are inevitably going to face. And the first runner-up prize goes to Diana Itzel Santana Galindo from Mexico. Diana's paper argued that AI can be a useful and ultimately essential tool for international arbitration and masterfully identified areas that are ripe for disruption now and where more development needs to occur. So congratulations, Sidesh and Diana, very well deserved. Finally, the winner of the emerging economies category is Reynold Ursua from the Philippines. Reynold wrote a very well-researched and persuasive piece, convincing the reader that ADR has tremendous advantages over slow and costly litigation in resolving climate change disputes. And he identified the traction that can be gained by ensuring environmental language is included in BITs. Congratulations, Reynold. I will now pass to Neil to tell us the winners of the global category.
Thank you, Chan, and hello, everybody. This is a bit like the Oscars, but I haven't got an envelope to open. But I can say that the global category pieces followed the trend of being of exceptional quality. And I have to say that I enjoyed reading them all, and I was well informed and stimulated by them. In the honorable mention category, the winners in no particular order are Alison Goh from SIDRA, Timothy Ho from LexisNexis in Hong Kong, and Akash Srivastava from NUS. Similar to the emerging economies category, these essays stood out as being of exceptionally persuasive, well thought out, and well researched, and very good to read. So congratulations to all of you. And now for the final award. The winner of the global category.
The second runner-up first.
The next is the second runner-up in the global category, and that goes to Nolan Young Kwang Lee from White & Case, Australia. Well done. Nolan identified with the wisdom of a young practitioner where we can evolve arbitration practice using AI, identifying limitations that come from the confidential nature of arbitration and its limited raw data. And she came to the relieving conclusion that arbitrators as decision makers are irreplaceable. That conclusion came to a great relief to me, and I'm sure to many others too. Well done. The first runner-up goes to Oscar Tang from Clyde & Co. in the UK. On the question of whether AI will help or harm the process, Oscar said that many lawyers have, in response to the important question, it depends, in getting to his conclusion. Oscar highlighted the disparity that may arise with an inequality of technological arms, but also fairly concluded that quick and dirty justice using an AI decision maker may be better than no justice at all. And now I open the envelope for the final award, and the winner of the global category of the first HK45 essay competition is Iris Ng Lee Shan of the Attorney General's Chambers of Singapore. Iris's essay stood out to every judge that was given an opportunity to review it, and I personally gave her top marks. Quoting Hemingway, Iris argued that the problem of climate change will occur first gradually and then suddenly. She argued that ADR can be a much more effective means of resolving climate change disputes where litigation is unavailable or undesirable. And she went on to highlight the creativity that ADR offers, matches the creative solutions that are necessary to resolve what may be the defining problem of the current generation. And it's really wholly appropriate that this award should be made today when we are just days away from COP26 in Glasgow, where these very issues are being debated on a truly global scale. So congratulations, Iris, on an outstanding piece of work, and congratulations to all of you who participated in this very worthwhile contest. Well done.
On behalf of HK45, thank you very much to the judges for helping us out with this process, and to everybody that continues to support our events. Definitely hope to see a lot of you at the pub quiz tomorrow, as well as at other events throughout the year. Thank you.
Thank you very much, and congratulations to the winners. Now we are going to take a 5-minute break, and then when we come back, we are going to listen the Honorable Chief Justice Andrew Cheng.
Argument is built with carefully chosen facts, arranged in a logical structure and presented in a compelling manner. Our global practice supports arbitrations with evidence presentations, technology solutions for remote and hybrid hearings, informational and persuasive graphics. FTI's evidence presentation professionals do more than put documents on the screen. We bring evidence to life, enlarging, highlighting, and comparing documents in real time. Our technology solutions like FTI's TrialMax Cloud, a secure single-access portal for our remote or hybrid proceedings, and our remote equipment kits ensure proceedings can operate effectively. Let FTI Consulting help you successfully navigate your arbitration.
This session, we will discuss Hong Kong courts and arbitration with dispute resolution experts, and we are very fortunate to have here today the Honorable Chief Justice Andrew Cheung with us. Chief Justice Cheung was appointed as Chief Justice of the Hong Kong Court of Final Appeal early this year. He will deliver the keynote address for this session. The floor is yours, Chief Justice.
Distinguished guests, ladies and gentlemen, I'm honored to be invited to speak at this session of the ADR in Asia conference as part of the 10th Hong Kong Arbitration Week. In the past 10 years, Hong Kong's status as a leading international arbitration hub has been continuously consolidated and developed. The strength of any place as an arbitral seat depends on a number of factors. They have been described by Lord Hoffman from the perspective of commercial parties who are in the process of choosing an arbitral seat as follows. The choice is likely to depend upon a combination of geographical convenience for the parties, ready access to good legal services, and a local legal system which can be relied upon to be impartial and exercise unobstructive supervision over the arbitration, intervening only when things have gone badly wrong. In this talk, I would like to make a few observations on whether parties to a Hong Kong arbitration can be confident that they will have access to, in Lord Hoffman's words, a local legal system which can be relied upon to be impartial and exercise unobstructive supervision over the arbitration. This invites two questions. First, what are the characteristics of Hong Kong's legal system? Secondly, what are the powers and functions of the Hong Kong courts in relation to arbitration proceedings? The starting point of any discussion of Hong Kong's legal system begins with the Basic Law. The Basic Law became the constitutional document of the Hong Kong Special Administrative Region upon its establishment on 1st July 1997, when the People's Republic of China resumed the exercise of sovereignty over Hong Kong. It was adopted by the National People's Congress, the highest organ of state power in the PRC, and was promulgated on 4th April 1990. Under the Basic Law, the legal system previously enforced in Hong Kong before the handover remains in place. Thus, Hong Kong continues to adopt the common law system. In particular, Article 8 of the Basic Law expressly states that the laws previously enforced in Hong Kong, that is, the common law, rules of equity, and ordinances, shall be maintained. And Article 84 specifically provides that the Hong Kong courts are able to refer to the precedents of other common law jurisdictions. As with other common law jurisdictions, Hong Kong's common law system adopts the doctrine of precedent. Legal precedents are typically established by authoritative decisions of the superior courts on matters of legal principle. In Hong Kong, the superior courts are the Court of First Instance, the Court of Appeal, and the Court of Final Appeal. In very general terms, the doctrine of precedent means that the legal principles laid down by the higher courts are binding on the lower courts when deciding subsequent cases involving the same or similar legal issues. This promotes legal certainty and ensures that like cases are treated alike, which are important features as well as virtues of the common law system. Crucial to the proper functioning of any legal system is the presence of an independent judiciary. This is firmly guaranteed by the Basic Law. Article 2 states that the Hong Kong Special Administrative Region enjoys independent judicial power, including that of final adjudication. Article 85 reiterates that the Hong Kong courts shall exercise judicial power independently, free from any interference. Members of the judiciary are immune from legal action in the performance of their judicial functions. Article 92 provides that judges are chosen on the basis of their judicial and professional qualities. Article 89 provides for judges security of tenure. It stipulates that a judge in Hong Kong may only be removed for inability to discharge his or her duties or for misbehavior by the chief executive on the recommendation of a tribunal appointed by the Chief Justice of the Court of Final Appeal and consisting of not fewer than 3 local judges. A special feature of Hong Kong's common law system is the sitting of foreign judges in the Court of Final Appeal. This is specifically provided for by the Basic Law. Article 82 states that the power of final adjudication vests in the Court of Final Appeal, which may, as required, invite judges from other common law jurisdictions. Article 92 provides that judges may be recruited from other common law jurisdictions. There are currently 12 judges on the list of overseas non-permanent judges of the Court of Final Appeal. 8 are from the UK, 3 from Australia, and 1 from Canada. As I've noted, the Basic Law expressly permits the Hong Kong courts to refer to the presidents of other common law jurisdictions. Having the very top judges or retired judges from leading common law jurisdictions, whose presidents may be, and in practice, are often referred to in our courts, is a clear and practical advantage for the development of Hong Kong's common law. The participation of overseas judges ensures that the Court of Final Appeals jurisprudence is, where appropriate, considered in the context of comparative common law. Further, the presence of overseas judges demonstrates their informed confidence in the rule of law in Hong Kong and the independence of the Hong Kong judiciary. As Ms. Justice Falk, permanent judge, pointed out in a recent speech, it is perfectly reasonable to ask whether any of these eminent serving and retired overseas judges would have sat or continued to sit in a court in Hong Kong if they thought the rule of law was in any way compromised or the judges were subject to improper interference. A further feature of Hong Kong's legal system that I would like to highlight, which is particularly relevant to Hong Kong's appeal as an international dispute resolution center, is its bilingualism. Hong Kong is the only common law jurisdiction in the world which is bilingual in English and Chinese. Article 9 of the Basic Law provides that both English and Chinese may be used as an official language by the Hong Kong judiciary. Section 5.1 of the Official Languages Ordinance specifically provides that a judge may use either or both English and Chinese in any proceedings before him or her as the court thinks fit. Judgments can be written in either English or Chinese. Section 5, 3, and 4 stipulate that litigants, witnesses, or legal representatives in any proceedings may use either or both English and Chinese to address the court or to testify. Most judges in Hong Kong are bilingual. In proceedings involving Chinese-speaking parties, it is not uncommon for a substantial portion of the underlying documents to be written in Chinese, even if the proceedings itself are conducted in English. As with most proceedings involving commercial parties, there is an obvious practical advantage in having a judge who can understand, for example, the arbitration clause which forms the center of the parties' dispute, and indeed any relevant documents in their original Chinese form. In short, parties to a Hong Kong arbitration can expect that the arbitration will take place against the backdrop of an impartial and bilingual common law legal system. I will now turn to the powers and functions of the Hong Kong courts in relation to arbitration proceedings. As a matter of general principle, the courts adopt a pro-arbitration policy. The general policy of the courts is to uphold arbitration agreements, to facilitate arbitration, and not to intervene in an arbitration, which is the party's free choice as to the method of dispute resolution. The role of the Hong Kong courts in respect of arbitrations can be divided into 4 broad categories. 1. Enforcing arbitration agreements. 2. Supporting the conduct of arbitration proceedings. 3. Ruling on applications to set aside arbitral awards. 4. Enforcing arbitral awards. As to the enforcement of arbitration agreements, under Section 20 of the Arbitration Ordinance, the Hong Kong courts have a duty to enforce arbitration agreements by staying court actions which are brought in contravention of a valid arbitration clause. The powers of the courts to support arbitral proceedings are prescribed by the Arbitration Ordinance. Section 3 of the Ordinance lays down the principles on which the Ordinance is based. 1. Subject to the observance of the safeguards that are necessary in the public interest, the parties to a dispute should be free to agree on how the dispute should be resolved. 2. The court should intervene in the arbitration of a dispute only as expressly provided for in the ordinance. Thus, the courts have the power to support arbitral proceedings only where this is considered a safeguard necessary in the public interest. Bearing this principle in mind, the court's functions and powers over the conduct of arbitrations include the following. 1. Granting interim measures of protection in support of pending or ongoing arbitral proceedings. 2. Ruling on challenges to the appointment of an arbitrator. 3. Reviewing an arbitral tribunal's ruling that it has jurisdiction over the dispute. 4. Assisting the taking of evidence by ordering a witness to attend arbitration proceedings to give evidence or to produce documents or other evidence. And 5. Determining the amount of fees and expenses payable to the arbitral tribunal in the event of dispute. Under the Arbitration Ordinance, there's no general right of appeal to the court against the merits of an award. Section 81 of the Ordinance, which incorporates Article 34 of Ancestral Model Law, states that an application for setting aside is the exclusive recourse against an arbitral award. An award can be set aside by the court only in the circumstances specified by Section 81, which are all fairly exceptional. It is worth emphasizing that the merits of the awards are not grounds for setting aside. Once an award is made, it can be enforced under Part 10 of the Arbitration Ordinance. Section 84 of the Ordinance states that an arbitral award, whether made in or outside Hong Kong, is enforceable in the same manner as the judgment of the court, provided that leave of the court is granted. Section 87 of the Ordinance provides that an award governed by the New York Convention may be enforced in the same manner as an award to which Section 84 applies. Similarly, under Section 92, a mainland award, that is, an award made in accordance with the arbitration law of the PRC, is enforceable in the same manner as an award to which Section 84 applies. In relation to an award to which Section 84 applies, although leave to enforce is not given as a matter of right, it will only be refused in unusual cases. There is a presumption that leave to enforce should be permitted. It is the firm policy of the law to aid the enforcement of arbitral awards. Part 10 of the Ordinance provides a list of grounds on which leave may be refused, namely, where 1. A party to the arbitration agreement was under some incapacity. 2. The arbitration agreement was not valid. 3. The party against whom enforcement is sought was not given proper notice of the appointment of the arbitrator or of the arbitral proceedings, or was otherwise unable to present his or her case. 4. The award deals with a difference not contemplated by or not falling within the terms of the submissions to arbitration, or contains decisions on matters beyond the scope of the submissions to arbitration. 5. The composition of the arbitral authority of the arbitral procedure was not in accordance with the agreement of the parties. 6. The award is not yet binding on the parties or has been set aside. 7. The award is in respect of a matter which is not capable of settlement by arbitration. And 8, the enforcement of the award would be contrary to the public policy of Hong Kong. The grounds that I have mentioned above are the only grounds on which enforcement of a convention or mainland award may be refused. In relation to a Hong Kong award, although the court retains a discretion to refuse enforcement if, for any other reasons, the court considers it just to do so, this discretion will be exercised only sparingly. It will be apparent that the grounds listed under Part 10 all involve unusual circumstances. Importantly, the merits of the award or underlying facts are not grounds on which leave may be refused. Further, even where one of the above grounds is established, the court will refuse enforcement only if the error is sufficiently serious. In summary, the pro-arbitration policy of Hong Kong law is reflected in the following. 1, the duty of the courts to stay court proceedings in favor of arbitration. 2, the power of the courts to support arbitral proceedings where this is necessary in the public interest. 3, the limited circumstances in which an award may be set aside by the courts. And 4, the presumption that leave to enforce an award should be granted. At the beginning of my speech, I have referred to Lord Hoffman's summary of the key considerations that commercial parties are likely to have in mind when choosing an arbitral seat. His Lordship then continued, there are not many places in the world which can satisfy all of these requirements. New York, London, Paris, Geneva, and Singapore are names which regularly come up. But Hong Kong also satisfies the requirements which I have mentioned, and is unique amphibious positioned in relation to China, being part of the territory of the People's Republic of China, but equipped with good legal services and an excellent court system, is coming to be recognized. Now, that was written in 2011. Hong Kong's unique advantage as a leading international arbitration center in this part of the world, as described by Lord Hoffman, has since been firmly recognized. I have every confidence that Hong Kong's stature as a leading arbitration hub will only continue to grow. Thank you.
Thank you very much, Chief Justice Cheung. Now our experts will discuss Hong Kong Court's contribution to international arbitration jurisprudence. For this discussion, we have Paul Shi, Senior Counsel at Temple Chambers, and Sapna Janjiani, International Legal Counsel at the Attorney General's Chambers of Singapore. This discussion will be moderated by John Chung. John is a partner at Freshfields and heads up Freshfields' China arbitration practice. Over to you, John.
Ladies and gentlemen, very good afternoon to those of you who have joined us in person, and very good morning, good afternoon, and good evening to those of you who have joined us virtually. Now, I'm very pleased to have with me two very distinguished panelists whom I'm sure are familiar to many of you. In the room here with me is Paul Shea, I'm Senior Counsel based here in Hong Kong, and joining us remotely, we have Sapna Janjiani, Queen's Counsel based in Singapore. Now, we've been very fortunate to have the Chief Justice's keynote speech on the role of the Hong Kong judiciary in arbitration. And I thought it'd be helpful for us to have a discussion around a couple of the key themes that have been raised in this speech. So Paul, let me start with you. The Chief Justice in his speech referred to how the Hong Kong courts seek to both uphold arbitration agreements and facilitate arbitrations. Now, in the past year or two, I'm sure you agree that there have been a number of interesting decisions coming out from the Hong Kong courts. Are there any particular decisions that stand out to you?
Well, almost every arbitration judgment from the leading common law jurisdictions would contain the mantra, we are pro-arbitration. So I'm not going to repeat judgments which contain that mantra. But there are a couple of decisions which are more than your usual mechanistic enforcement cases, some involving Sabna's jurisdiction in Singapore. And I know she may be very tempted to discuss that. I mean, you know what I'm referring to, I mean, VTB, but I'll leave that to you because obviously that's a matter of common interest to us. But in the Hong Kong context, there's an interesting case called CND, and there is also a recent decision by Madam Justice Mimi Chan called SCNOE1, which I would touch on very briefly. The CND decision dealt with what seems to be a very well-established distinction in the arbitration context between admissibility of arbitration on the one hand and jurisdiction on the other. CND itself involved what's called a tiered dispute resolution clause, requiring good faith attempts to negotiate, etc., before you can actually commence arbitration. And the point was taken that a failure to fulfill the good faith negotiation requirements in the agreement rendered the award one which is rendered without jurisdiction. And the judge surveyed an array of authorities, and this is something which, again, we may touch on later, which shows, you know, how in the world of arbitration, maybe there's no boundaries because, I mean, for as long as everyone subscribes to the same regime, cases are interrelated and all citable across the border. So the judge looked at the usual texts, Gary Bourne, etc., American, and also looked at cases from various jurisdictions and came down in favor firmly of the establishment of this distinction and found on the facts that the tiered clause amounted to an objection on admissibility only. But of course, there are different ways in which these objections can be mounted, time bar, res judicata, and I guess every case depends on the facts, and I know the case is going on appeal, which will be heard in Q2, I think, 2022. So again, all that remains a bit open. The other case that I have in mind is the decision by Madam Justice Mimi Chan, SCNOE1, which deals with what would, in a litigation context, have been dealt with under the slip rule. Basically, parties argued the matter before tribunal, but the tribunal omitted in the dispositive order part omitted to give injunctive relief and perpetual licenses as prayed by the claimant, even though it had made all the necessary findings of breach in the body of the award. So the question turns actually on the technical argument as to whether or not the case falls within the language of a clerical mistake, because the statute provided for the tribunal to be able to correct itself if there's an arithmetical, typographical, or clerical mistake. And it was held that if you just omit to deal with a point, it's not clerical. It's simply a mistake in your thought process. You just forgot about it. But the matter was saved by another route, namely that the tribunal actually was held to have the power to do a self-help in the event that it actually omitted to deal with a fact not dealt with. Because the argument was that, oh, you didn't actually omit to deal with the fact, the argument, because the tribunal actually had a sweep-up provision saying that apart from declaring that there's a breach, everything else is dismissed. So the respondent said, well, tough luck. You've actually dismissed everything else. So you've actually dismissed the injunction claim as well. But the tribunal said, look, we've obviously just omitted or forgot to deal with it. We haven't actually dealt with it by dismissing it. So whether you deal with it under litigation rule of slip rule in court, or whether or not you deal with it in an arbitration context, that there's a remedy somewhere. And I think the decision by Madam Justice Mimi Chan basically underscored the point that the tribunal is to be expected to be the master of its own procedure. Where there's a mistake, the tribunal is equipped with powers to correct itself, and the court should really not intervene in such matters. So these are really two rather recent developments when, you know, certain points and aspects of the ordinance are picked up.
Yeah. certainly two very interesting cases there. Seth, if I can now turn to you. I mean, the C&D decision in particular that Paul mentions is a very interesting one, because as Paul said, in a way, the C&D decision drew upon the distinction between admissibility on the one hand, where that is within the power, where the tribunal is fully empowered to decide those questions, and yet, on the other hand, the question of jurisdiction, where the courts are prepared and able to intervene. And of course, in that case, essentially, really, what the courts seem to have held, at least at first instance, is the idea that they are prepared to, in a way, cede jurisdiction, using the word jurisdiction loosely, cede jurisdiction to the tribunal on at least certain questions, such as preconditions to arbitration. Now, looking beyond that, though, are we seeing a more general trend, whether in Singapore or beyond, where the courts are taking on this pro-arbitration approach, ever more comfortable in deferring to decisions made by tribunals? Or conversely, are you seeing a little bit of a pullback, perhaps a bit of a temptation, possibly in cases, in a way like the SC case that was mentioned, where the courts felt it was necessary to step in, possibly to assist in the final determination made by the tribunal?
Thank you, John. That's a great question. May I firstly just say what a pleasure it is to be able to beam into this conference and join you all virtually. I'm a very loyal supporter of Hong Kong Arbitration Week, so it's great to be able to participate this year remotely. Secondly, just a preliminary point, any views I share, of course, are very much my own personal views and not those of my employer, the Attorney General Chambers of Singapore, which I cannot mention without congratulating my colleague Iris Ng, who I just saw won the HK45 essay competition. Now, to look at your question, firstly, the case of C&D. The development of the distinction between admissibility and jurisdiction that we see in C&D, I think it's really important. We've seen this distinction for some time in investor-state arbitration, and I think it's been much needed in commercial arbitration. And now we've seen decisions in Singapore that were cited in C&D. We've seen decisions in England, and it's fantastic to see the Hong Kong courts going this way, even though the case, of course, is subject to appeal. Defects in admissibility are going to be much easier to cure, of course, than defects in jurisdiction. But what we see is that the courts will robustly enforce clear agreements to arbitrate and will leave issues of compliance with pre-arbitral conditions very much within the purview of the tribunal. But to pick up on your question, does this mean that courts are ever more comfortable deferring to decisions by a tribunal? I don't think it's straightforward, because I think being a pro-arbitration court means that you defer to an arbitral tribunal when you consider that fundamental principles under the New York Convention haven't been breached. So, for example, where it comes to compliance with pre-arbitral conditions. But I think a pro-arbitration court has to demonstrate that it will not hesitate to step in when it considers that there has been such a breach. And if we stick to the issue of jurisdiction, I think there are a couple of cases that are quite interesting in this regard. The first is Dalla and Pakistan, where the UK Supreme Court refused to allow enforcement of an arbitration award against Pakistan. It found that the tribunal had erred in its decision of jurisdiction and didn't hesitate to substitute its own. The Paris Court of Appeal, of course, took a very different view, reached the opposite conclusion. So two pro-arbitration courts reaching different views on the level of deference to be granted to a tribunal's decision on jurisdiction. And we saw a similar divergence of views between the Paris and UK courts in the 2020 case of the wonderfully named Kebabji and Coop Foods, where again the English courts found that the tribunal had erred in finding jurisdiction against the non-party, and the Paris courts disagreed. A bit closer to home, the final case I'll look at is the case of PT First Media and Astro. And that's an example of a case which surprised many. In that case, a Singapore Court of Appeal found that the tribunal erred in its decision that it had jurisdiction over certain of the respondents and refused to grant enforcement of the award against those respondents, even though the respondents had not sought to set aside the partial award on jurisdiction. So I think that the answer to the question in summary is that pro-arbitration courts are continually straddling this line between interference and non-interference. And we've seen the contours of that line evolve. Now, C&D has shown that issues of compliance with pre-arbitral conditions now fall very firmly, I hope, on the non-interference side of the line, and that's a welcome development. But firmly maintaining that line in place and not hesitating to interfere where it's warranted, for example, in refusing to uphold an arbitral tribunal's decision on jurisdiction when the court believes that the tribunal has erred, I think that's a really important aspect of a court being pro-arbitration. I think we're going to see the contours of the line develop more in the future, but I think it can be a tricky line to straddle, and we don't always see harmonization amongst all the courts, even those that are considered pro-arbitration.
Thank you, Sepna. Yes, never an easy answer really here. And you touched in particular on the word harmonization, and I think picking up on the phrase that you used earlier, Paul, around interrelationship and how interrelated really the systems and jurisprudence is, possibly in the arbitration space. So let me come back to you, Paul. In Hong Kong, are we seeing any signs of cross-fertilization as well, or harmonization between Hong Kong, for example, and where we're seeing jurisprudence or legal developments outside of Hong Kong? So are we seeing cases, for example, where the Hong Kong courts are adapting what we have from abroad and adopting them to some extent in Hong Kong, but within the unique context of Hong Kong's own system, and possibly even improving upon that?
Well, following on from what the Chief Justice had said, because there's a wider answer and a narrow answer. In the wider context of the legal system of Hong Kong, I mean, we have the privilege of being able to develop Hong Kong common law. So jurisprudence from, in fact, any common law system would be of highly persuasive value in Hong Kong, plus the cosmopolitan nature of our Court of Final Appeal. So we are not just Anglo-centric. I mean, we can be Australian-centric, and we can be many common law system-centric. So in terms of general citation of authorities, I mean, we have been rather cross-fertilized anyway. But in a particular context of arbitration, I mean, even in the context of the cases that we have just looked at, I mean, for example, C&D, I mean, if basically we cross-fertilize and rely a lot on other jurisdictions which are signatories to New York Convention and also the model law. So in C&D, we looked at Singapore Court of Appeal decision, I mean, you know, BBA, and also we looked at English decisions. We looked at U.S. Supreme Court decisions, and even in the Da Yang decision, which differed from a Singapore Court of Appeal decision, we more or less looked at the same international jurisprudence as the Singapore Court of Appeal had, except that we interpreted them a bit differently. We looked at the same East Caribbean cases, we looked at the same English case, but we just differed. So yes, we looked at the same pool of international materials. There is cross-fertilization in that sense, but in line with the common law tradition, different system would be free to interpret them with fine, nuanced differences here and there. But we hope that the regime is uniform, but you just don't have a supranatural body compelling every court to apply the same rule in every case. So that's the beauty of the common law. Agree?
Absolutely. And I think the Da Yang case, in a way, is a good example of both harmonization and yet, as you say, a situation where the Hong Kong courts seemingly have come out in a different position compared to, I believe it's VTB case that you're alluding to in Singapore. Sepna, so perhaps putting you on the spot a little bit, I suppose a little bit more from the Singapore perspective. Can you tell us about this seeming difference between the approach taken in Hong Kong and Singapore, and any additional views you have on the reasons for the difference? I won't quite put you exactly on the spot in terms of who's got the right answer there.
I may tell you anyway. So just for background context, let me talk a little bit about the case. So in Singapore, if an unpaid creditor applies to court to wind up a debtor, the court will allow the application to proceed unless it finds that there is a bona fide and substantial dispute as to whether the debt is owed. So that's a threshold test. In the VTB and Anand case, the court held that if the debt is subject to an arbitration agreement, then a different standard should be applied. So where there's a valid, applicable arbitration agreement, unless there's an abuse of process, so a much lower test, all such applications should be stayed in favour of arbitration proceedings. Now, one of the reasons given was that there should be consistency with the approach adopted by the court when deciding whether to stay proceedings brought before the court, so non-insolvency proceedings, in favour of arbitration proceedings. So very much the theme of this being a pro-arbitration approach. But what it means in practice is that when a winding up application is presented to the court, it will be easier for a debtor to have the proceedings stayed if there's an arbitration agreement underlying the debt. So essentially, coherence in the area of winding up applications has been sacrificed in order to have coherence with the approach when applying for a stay in favour of arbitration proceedings. Now, as Paul mentioned, the Hong Kong courts don't follow this approach. There had been a couple of cases where they did follow that approach. I think it was a Lasmo case, if I'm not mistaken.
Yep.
But now,
Justice Jonathan Harris. Yep.
Yes. But now in the Dayang Marine case, which you mentioned, Paul, the Hong Kong High Court has applied the same test for a debt subject to an arbitration agreement as for a debt subject to litigation. And there isn't consistency across the common law about which approach should be adopted. In England, we have the case of Rhys Salford, which the Singapore court followed in the VTB case. We have Malaysia following the English-Singapore position, but we have BVI and Ireland following the Hong Kong position. My own view is that I hope that the approach in England and Singapore is revisited. I think it has swung the pendulum too far, if I may say so. I assume that the approach was taken from a very much pro-arbitration standpoint, but I believe that it interferes with well-established principles of insolvency law in order to fix a problem that doesn't need to be fixed. And I note that the Chief Justice in his remarks said that, you know, being pro-arbitration means that you have to safeguard the arbitral process where necessary. My view is that the VTB approach isn't a necessary support of the arbitral process. So again, I do hope the approach is revisited, and I'm in favour of the Dayang Marine approach of the Hong Kong courts. So I have given you my views, John. I could not resist.
Well, thank you very much for that, Sam. Then it's certainly, I think, a very topical issue, and indeed one that I encountered earlier this year in the context of Cayman proceedings. And essentially, as Sam, now you explained very helpfully, a distinction between, in the context of a winding up petition, where you already have an agreement to arbitrate, and you're trying to, as it were, stay or dismiss that winding up petition, whether you apply quite a low bar and you simply run after the courts and you say, I've got an agreement to arbitrate, there's a dispute here, it should just go to arbitration, or whether you need to meet quite a high bar, which is in a way suggested by the Dayang case, the somewhat higher bar, that there has to be a bona fide dispute with on substantial grounds before the winding up petition will actually be stayed. Now, I suppose, and here I'm conscious I'm speaking to a room full of largely arbitration practitioners. Many people in this room, however, might take the view, well, if you've got an agreement to arbitrate and the other party tries to run off and wind up a party, then that question of the dispute should actually be palmed off to the arbitration tribunal rather than resolved via the winding up petition, as it were. Paul, any final views on this really interesting question?
Well, unlike Sapna, who has the benefit of having an appellate decision which has basically settled the point, and she can actually express a personal view. The point in Hong Kong is actually quite unsettled, you can say, because actually before Dayang and before the last MOS, there were actually an earlier line of Hong Kong cases pointing in favor of the requirement of a bona fide dispute. So the matter in Hong Kong is rather in a state of flux, and therefore, I mean, one wouldn't want to actually stick one's neck out to place a bet in case one is later briefed to argue the other side. But I think it ultimately comes down to a matter of policy, because as Sapna says, you adopt one test, coherence in that area, coherence would be sacrificed in the other area. You see what I mean? Because if you adopt the pro-quote arbitration test, you sacrifice coherence in the winding up context. And it depends on what conference you talk in. Because I'm quite sure Jonathan Harris is speaking in an insolvency conference. He actually says it's a really jolly good idea to adopt his test. So it's really a conflict of different regimes and different policies, which can only be resolved by further appellate work. And in Hong Kong, there actually has been no binding appellate decision which focuses on that particular point, because again, in usual common law tradition, where courts can resolve a matter on the facts, they rarely wish to actually resolve a point that they need not decide. But this is a point that I suspect the Hong Kong Appellate Court would have to grasp the nettle with, because in line with other jurisdictions which had, you know, one way or the other, laid down the law, I think that it's not too long when the Hong Kong Appellate Court would be called upon to do so.
So there you have it, the pro-insolvency approach versus the pro-arbitration approach. I see we're out of time, so I will spare everyone from asking you to raise your hands and vote on this issue. But rather, it remains for me to thank both my panelists, Paul and Sapna. Thank you very much for joining us for this really interesting and invigorating discussion. Thank you.
Thank you very much. While we move on to the next session, I want to remind you again to scan the QR code and log into the platform for questions, because in this session we are going to use the polling mechanism. We are going to discuss the rise of digital currencies with Andy Meehan from Gemini, Lucy Gazmarian from Token Bay Capital, and Simon Chapman. Simon is a partner of Herbert Smith Freehills, and today he will moderate the discussion.
Thank you so much. And I know this panel has been eagerly awaited all day. This is our session on cryptocurrency, and it's deliberately quite a brief session this afternoon, not only because I think we're running slightly over time and we're one of the last sessions of the day, but also because we wanted this to be really more of a teaser for a slightly more detailed session next year. But we felt we couldn't discuss the future of disputes without talking about crypto. Everyone in this room will be aware of the huge focus on this industry in the press, certainly over the last 12 months. The current value of the crypto market, when I checked yesterday, is estimated to be around $2.5 trillion US. And much of that growth actually has come from Asia, including Hong Kong, which is home to some of the largest crypto platforms globally. But as is always the case with technical innovation, the crypto space presents new uncertainty. It creates challenges and risks. And with challenges and risks come obviously the potential for disputes. But we're not going to talk very much about disputes today. Instead, we wanted to focus on some of the fundamentals of the crypto industry, delving into some of the buzzwords around DeFi and blockchain, NFTs, and all of the other acronyms that no doubt you will have heard about. And we'll touch on some of the controversy surrounding crypto, some of the concerns people have raised about regulation, compliance issues, ESG, and we'll be keen also to get your views on some of these points as well. That's why there was the reminder to scan the QR code for those of you in the room, because this is going to be an interactive session. Not in the sense that we're going to pick on people to give us their views on particular issues, don't worry about that. But we are going to run a few straw polls as we go through some of the issues today, just to get a sense for what those of you in the room and those people that are joining us online think about some of these issues. So keep your phones or your tablets to hand as we'll be putting up some polling questions over the next 30 or 40 minutes. And thankfully, you're not going to be hearing from me on some of these issues. We've got two genuine experts in this space joining us this afternoon. I'm joined in the room by Lucy Gazmararian, the founder and managing partner of Token Bay Capital. Lucy is also a board member of the FinTech Association of Hong Kong and the founder of Women in Crypto in Hong Kong. Lucy's business, Token Bay Capital, is a Hong Kong-based venture fund which focuses on digital assets and blockchain investments in the Asia Pacific. And prior to setting this up, Lucy was also a senior leader of PwC's global crypto team, where she advised a wide range of entrepreneurs, startups, and financial institutions on crypto and blockchain projects, as well as working with some of the world's central banks and other regulatory bodies to help formulate their crypto asset policies. So Lucy is, in other words, one of the foremost experts in this space, and we are really fortunate and delighted that she is able to join us at the ADR conference today and help bring us up to speed on some of the fundamentals of crypto and perhaps debunk a few myths along the way. And joining us on the screen is Andy Meehan, who many of you will know. He's joining us from his new home in Singapore, but he'll be a familiar face to many of you in the room from his time in Hong Kong. Andy is the Chief Compliance Officer of Gemini, a next-generation crypto platform founded in 2014 that allows customers to buy, sell, and store digital assets. Andy is, as many as you will know, a New York qualified attorney who spent more than a decade in Asia, both in private practice and as in-house counsel and compliance officer. And in fact, prior to joining Gemini, Andy held senior positions at both Credit Suisse and Morgan Stanley. And so he brings a real wealth of experience to this discussion from across the financial services sector. And perhaps inevitably, I think, given his current role, Andy's got a particular interest in some of the regulatory issues surrounding the crypto space. And for those who haven't already, I would recommend his recent piece in Regulation Asia on the relationship between the crypto industry and global regulators. It does pick up a number of the key themes that hopefully we'll have time just to touch on over the course of this afternoon. So thank you both for joining us. It really is terrific to have you on board. As I mentioned, we will have some interactive polls. There will also be, hopefully, a little bit of time at the end for questions. For people in the room, you can raise your hand. For those of you online, you can submit your questions through the online portal. But I thought I'd start just really by asking both Andy and Lucy if you could just tell us a little bit about how you came to be involved in this industry and what specific aspects of the crypto sector you focus on. Lucy, perhaps if we could just start with you.
Yeah, great. Thank you so much. We're really thrilled to be here, and thanks for sticking around for the last session. Hopefully it'll be an interesting one for everyone. So I came into crypto, actually it was an epiphany for me. So I spent about 16 years in traditional finance. So I was with Goldman in London for many years on the institutional side, and Credit Suisse as well in Singapore. And I got to a point where I was a bit disillusioned with the banking system. You know, I'd lived through the GFC. I think I joined Goldman just 6 months before the great financial crisis, which was not great timing from a salary point of view. But really lived through actually very difficult times of how that industry had to restructure itself, right, in the wake of, you know, enormous seismic shifts with Lehman Brothers going down. And I don't think banks really ever got to that sort of profitable, exciting level that they were at before. Those sort of heady heady banking years had gone. And, you know, it got to the point where I was managing traditional money at Credit Suisse in Singapore. And it was sort of selling products that clients don't want, right? There's nothing more soul destroying than selling customers of a bank products they don't want. So I knew fintech was happening. I could see it happening all around. And I really made a conscious decision to do a pivot, a career pivot. And so in Davos, I got myself to Davos in 2018. And I don't know if you remember when all the ICO boom was happening, which means that you couldn't have a conversation with anybody that wasn't trying to sell you a token that was going to change the world, raise 100 million, and 80% of them were scams. And they're probably all living very happily on these islands drinking their pina coladas. I happened to be in Davos during that time. And, you know, while there were all the scammy discussions, I was actually lucky to be privy enough to some of the conversations in Switzerland, which is obviously a world leader in crypto, with incredibly intelligent people talking about decentralized networks, the downfall of governments, nation states, and I was absolutely transfixed. So for me, it was a very specific moment. It was actually a specific panel where I could see how transformative this technology was. So it was more than just Bitcoin. It was it's technology, and it's a movement. And then, as luck would have it, fate played its hand, and someone was in the mountains as well, hiring for PwC's crypto team in Hong Kong. I was born in Hong Kong, so I'd wanted to come back here. And then the crypto journey started. And for me, given my corporate background, there was really no better way to get into the space than, you know, I liked that it was from PwC, trying to do the right thing for the industry, trying to apply rules and regulations, regulatory frameworks, and helping the crypto businesses that actually were not money launderers and were not trying to scam you out of millions, do the right thing and grow really exciting new businesses. So therein, I'll pause there, but I spent almost 3 years with PwC. Yeah, brilliant.
Thanks, Lucy. Andy, what about you? How did you get into this space?
Yeah, first of all, it's great to be back in Hong Kong, if only virtually. Certainly miss our times there and all the good friends and colleagues that we had over the years. I got into crypto much later than Lucy, so this is a fairly recent leap for me. You know, I think there are certainly like two kind of generations of those of us in crypto. Lucy probably like on the tail end of the first generation, which I would consider to be more of like the true believers who felt like this was a revolutionary kind of invention that was going to change the world and change how we think about lots of different things, not just in the financial space, but across the spectrum of industry. And then there are those of us who kind of stumbled into it because it seemed interesting and maybe there was just a chance to do something unique. So, you know, I don't have a beard and I don't do CrossFit and I'm not a vegan, so I wasn't in like the original Bitcoin Bro Club. But while I was at Morgan Stanley, we had our head of global financial crimes, gentleman by the name of Noel Perlman, who left you know, this very prestigious position at a very prestigious firm to go be the CCO for Gemini at the time when it was just a startup. And you know, obviously we all thought the old man has just lost it, and it was a bit of a shock to everyone. But that's when I kind of started really looking into the space, because this was a person that I really greatly respected. I knew he wouldn't do anything that he hadn't very carefully considered. And so I took a couple of courses. There's some interesting you know, courses for those who are very new to the space put on by MIT or London School of Economics, where you can really get a solid foundation as to what the background of this industry is and what blockchain is about. And the more I started exploring it, the more interest I took in it. And I thought, at this point in my career, you know, I maybe have one more chance to go do something really different. And this was it. And so I haven't looked back. It's been an incredibly steep learning curve for those of us not steeped in the technical jargon and you know, the very mathematical aspects of how blockchain works and how that kind of is translated into the financial space and the kinds of terms and products and agreements that we're more used to. but it's been a great experience. And you work with really fascinating people, and every day it's something new where you truly are in uncharted territory, where there aren't really any regulatory guidelines or even even fence posts to sort of light the way. They're really exploring new space, which is fun.
Thanks, Andy. Now, Lisi, when you and I first spoke about this a couple of weeks ago, you said that you only have to mention the words Bitcoin or blockchain to certain people and they look terrified, genuinely terrified, or they have no clue what you're talking about. So I have a pretty terrible open first question for you, which is, could you just explain to us as briefly as you can how it works?
Yeah, as I said earlier, thank you so much for the really easy opening question. But no, it's true. I mean, there's nothing that frightens grown men more than the word crypto and blockchain, and I've seen it time and time again. And I think, first and foremost, it requires a different way of thinking about things. And the minute you do that, it really opens up your mind to how everything works. But if I really had to do an elevator pitch on, what crypto and blockchain is, I'd probably use Bitcoin as the example, right? It is the original cryptocurrency. And I think in its essence, why it's still so powerful and it's still gaining traction and hitting all-time highs, I think we're 12 years in now, is because it really captures what this technology is about. And fundamentally, this is a new technology. And it's being applied in a way that is then very transformative for both our social, but economic and financial lives. So with Bitcoin, really, what it managed to do was enable someone to send something that represents value on the internet from one person to another person, and you could be confident that that payment had only happened one time and that person had not sent that same $100 to 10 other people. And why I say that's really important technology, enabling technology, is because there's no DBS bank in the middle, there's no HSBC that we all rely on to verify that transaction. So that payment happens across the Bitcoin blockchain. That replaces your HSBC and your DBS, and you can do it on the internet. So it's code. We're talking about software here. But if we collectively agree that one Bitcoin is something that represents value, and believe me, on day one, no one thought Bitcoin represented anything of value. It was just an experiment in the technology. But that has gained traction. It's like, wow, we can transfer value from one person to another over the internet. And if we start believing that there's value in it, because obviously there's a finite supply of Bitcoin, 21 million will only ever be there, and it starts gaining traction, people start using it because it's an easier way to pay people than going through the SWIFT network and different bank accounts and all of the clunky system we have in place today. At its essence, crypto is peer-to-peer technology. And that's why it's so empowering for the individual, because everybody can take part in this. You don't even need a bank account to participate in this, because we're all just operating with digital wallets on the internet. That's all you need. So that I would say is the core. And then when you see all these other thousands of tokens listed, it's just tokens that have different features and functions. If you remember that Bitcoin is just software, it means that you can code in more complicated things than just a payment transaction. You can code in, via smart contracts, you can code in many different functionalities. And there we have Ether, and we have a new sort of infrastructure, if you like, for our financials market. But essentially, we're talking about peer-to-peer technology.
I think that was the perfect elevator pitch. And hopefully most of the people in the room understood it. There are lots of people nodding, so I think they're at least pretending that they understood it. So thank you. Andy, I have more of a lawyer's question for you. One of the issues really that we've posed in the title for this session is whether crypto is a form of security, or whether it's an asset, or whether it's a currency. And I wonder if you could just tell us briefly how different jurisdictions have approached that question, and why it's important?
Sure. So I've seen crypto described as a regulatory platypus, which is probably an apt description because it takes little bits and pieces from lots of other things that we know and sort of throws it all into one new creature. I think part of the challenge here is we tend to want to classify things based on things that we already know. And as Lucy described, this is really a new technology. It's difficult to compare it to things that have come before. And I think that is why we see various jurisdictions describing and classifying crypto as different things. In Singapore, UK, some other Commonwealth jurisdictions primarily, it's often looked at as a type of payment device. It's not considered the same. It doesn't have the same legal status as currency in anywhere except for El Salvador currently, but it's considered more of a banking kind of product that would tend to be regulated by the banking regulator. In places like Hong Kong, it's a commodity, same in the US, and generally subject to the Securities Commodities Regulator. In some places, of course, it's illegal entirely, like in China, except even in those locations, even in China, it is still considered property. So it could be subject to taxes, it can be transferred and recognized as something of value in property disputes or inheritance or what have you. But the big issue is that there isn't a single framework for thinking about what crypto is, which makes it challenging and will become even more challenging as some of these disputes regarding cryptocurrency mature and come to be heard before arbitration centers or courts, because how that is classified, whether it makes sense to be classified, in the same manner as things that we already know or not, that will determine the laws that are applicable to how we treat this when it comes to disputes, on top of how regulators are going to treat it. So I think the industry as a whole recognizes that this is a big challenge and something that has to be resolved. I think there are a number of reasons that we can maybe get into later if we have time as to why regulators in different jurisdictions have their own reasons for treating these as they do, whether that's self-interest or consumer protection reasons or what have you. It's going to be a challenge to come up with some kind of a universal mechanism for how we think about this and how we resolve disputes involving crypto.
Thanks, Andy. I think that's probably a good time if we could get up our first polling question. Hopefully we can get that up on the screen. We're just waiting for our own technology to work. Maybe just while we're waiting for that question, everyone in the room, if you can get your apps ready to answer the poll. You should hopefully see that. For those of you using the app, it should hopefully be on your mobile devices. It's now come up on the screen in front of me. So the first question we wanted to put to you was, cryptocurrency platforms are widely used for money laundering. True or false? Let's see what people think about that question. We'll leave that up for about 30 seconds to give you a chance to put in your answers. Lucy, maybe while people are giving that some thought, do you think we'll see a wider adoption of DeFi, I think is the language that's used, decentralized finance, going forward? Why has that become so popular?
Yeah, so at the outset, when I really set the scene, if you like, for what crypto and blockchain is, when I say it's peer-to-peer technology, it's quite revolutionary, and I will use that word. If you apply peer-to-peer technology to the delivery of financial services. So no longer do we queue at banks, go to banks, rely on banks. We rely on protocols, which is just code that we all agree on. And collectively, we can deliver financial services to each other via smart contracts. We don't need to know each other. We don't need to see each other. This is all just done on the internet, but it is essentially DIY finance. And DIY finance is revolutionary because we really need to remember that over 30% of the adult population globally is unbanked. So many people do not have access to bank accounts. Our financial system is so exclusive. It is not remotely inclusive. If you give the potential for people to deliver financial services to each other via their smartphones across the whole world with no barriers to entry, there's no KYC, there's no bank account, you just need to set up a digital wallet, which takes probably 15 seconds. You suddenly have the whole world innovating with finance. And the way the world goes round is through finance. And that is why we are seeing an explosion in something called DeFi, because we have now a sandbox of innovation where anybody is saying, I'm going to create a group, an ecosystem governed by a smart contract and a protocol. And if you think it's great, you believe in the team, you like what returns you're going to get, join us. And you can do that instantly. And that's very, very revolutionary because suddenly we're not going to need banks.
Well, our poll has closed, and it looks like a majority of the people in the room do think that cryptocurrency platforms are widely used for money laundering. So, Andy, this might be a good time to touch on this subject of regulation. Why have regulators taken an active interest in this area, and what do you see in terms of future trends for the regulation of crypto?
Yeah, well, I think that's the answer. I mean, that poll is exactly why regulators have taken an interest in it. Now, is that poll reflective of reality? No, but the perception is often what drives decisions. If, from a statistical standpoint, I think it is fair to say that the early days of cryptocurrency, Bitcoin in particular, the stories of transactions on the dark web, which is like the black market of the internet, narcotics trafficking and transactions, other sorts of connections to nefarious individuals and groups. Look, they existed just as they do in any other industry, any other form of transferring assets from one party to another. But if you look at how much of this is actually being done with, and we'll just use Bitcoin because it's the most widely used crypto. Last year, less than 0.5% of Bitcoin transactions had connections to illicit individuals or groups or activities. Compare that to around 4 to 5% of cash transactions, at least as estimated by the UN. And I think people are discovering, and regulators and other vendors are catching up with the advantages and the abilities of that the blockchain provides to those who want to make sure that transactions on it are in fact transparent. I mean, when it comes down to it, any blockchain derived cryptocurrency is a terrible mechanism for doing anything illegal because it's incredibly easy to see exactly where that transaction has gone. And while wallet addresses may be pseudonymous, in other words, not a real name attached to that wallet address, or it doesn't have to be a real name attached to that wallet address, I think the investigations conducted by law enforcement that have received significant publicity over the last couple of months or so have demonstrated that it's not that difficult to find out who actually owns these wallets and to trace and recover that Bitcoin, which you could never do with cash. And so, while I think the bad reputation of Bitcoin in the early days, it was exaggerated, perhaps not entirely undeserved, but as this becomes more mainstream, as reputable players come into the market, as more and more people demand kind of a transparency and accountability, which drives these vendors to offer services such as this blockchain monitoring capabilities, you're going to see Bitcoin become, one of the cleanest ways of transferring assets between parties.
Well, just on that topic of illegal activity, let's get our second polling question up, if we can, on the screen, because I'd be interested for people's views on this particular issue. And our second polling question is asking, cryptocurrency trading is illegal in many developed markets. Do you think that that is true or false? And for those of you that were listening particularly closely to the SJ's remarks this morning, you'll know the answer for Hong Kong at least. Lucy, while people are thinking about that particular question, we've all read about the clampdown in mainland China recently. To what extent do you think that that will have an impact on the future development of the crypto business?
Yes, so I'm probably one of the few that's actually very optimistic about Hong Kong's crypto future. But the reason I say that is because it is more than cryptocurrency. As I said right at the outset, it is a technology, and there are different elements of it that the mainland is adopting faster than the rest of the world. Blockchain was a national strategy in China from 2016, and they understand the power of the efficiency a blockchain brings, and often an associated token. By way of example, NFTs are not illegal in China. McDonald's in Shanghai just issued 188 NFTs. So they are embracing this from a sort of digital collectibles point of view. What China has publicly said, and I've heard this directly from the Director General of the Digital Currency Institute, this was 2 years ago at Hong Kong FinTech Week. He said the rise of the digital yuan, which are about to roll out, was in direct response to the threat of Bitcoin. And the reason he said that is because if you single out Bitcoin, there are many different types, iterations of this technology. You've got, I'm not going to do a 101, but you've got security tokens, utility tokens, cryptocurrencies, CBDCs. So there's many different ways to apply the technology. And he said Bitcoin was a threat, is a threat, because it threatens the monetary sovereignty of the digital yuan and the Chinese government's ability to control, the nation in a sense, because the money, your national currency, is the lifeblood of a country. And if everyone starts adopting Bitcoin and everyone does DIY finance and payments, where does that leave the power of a government? Taxes. Suddenly everything can crumble very, very fast. And I do actually think it is quite a real threat. We can come on collectively to discuss whether Bitcoin becomes the world's reserve currency, but China is not subscribing to that, right? So it's very much Bitcoin specifically. DeFi, I think they will adopt, but it's so new. It's also quite revolutionary in terms of how it can threaten banks. If everyone's doing DIY finance, DIY payments, it's systemically important institutions, which are all the main banks in China, that could really be under threat, and it could happen very fast. So I think in the short term, China is being ultra cautious. They're getting their digital yuan issued, which is crypto, by the way, and they want to sort of be on the front foot with that. When it comes to the recent consultation paper in Hong Kong and what moves they're making in Hong Kong specifically, they are looking to take retail out of this equation. And that is going to be a hit to cryptocurrency exchanges, of which Hong Kong has historically been quite a hub. People don't realize what a crypto hub Hong Kong is. We've got FTX, we've got crypto.com, we had BitMEX, now rebranded, I think, 100x, a number of different exchanges, because Hong Kong is a global financial hub, and crypto is the new, depending on the way you look at it, the new way to deliver financial services. So, so they're removing retail from the equation, but it is not illegal for professional investors to invest in cryptocurrency. So the way that I look at it is actually Hong Kong is becoming China's crypto hub. A lot of ATMs are popping up, and when the borders start opening and Chinese tourists come back again, it's going to be very interesting to see how busy those Bitcoin ATMs get. you know, I think it's going to be managed. OSL is a publicly listed crypto exchange on the Hong Kong Stock Exchange. They have a license from the SFC. So institutional movement and investment in Bitcoin and cryptocurrencies, I think, in my opinion, is here to stay in Hong Kong. I think like Hong Kong has been a hub for the US dollar, you know, they're an offshore hub for many different instruments that are not allowed on the mainland. And it works very well, if you ask me, for China's overall strategy. So in my opinion, and from, you know, discussions I have, I think we're seeing a lot of mainlanders that are Bitcoin billionaires, if I'm honest, getting Hong Kong passports, coming over here, they feel more free. And for at least the near term, 2 to 3 years, I think crypto is going to be, in a controlled way, allowed to develop and grow, and hopefully position Hong Kong as a financial hub that's a digital financial hub, because you can apply this technology to capital markets. And as China opens up their capital markets, they're probably going to want to showcase this technology for stocks and bonds, the Wealth Connect, Stock Connect, Bond Connect, in addition to their digital yuan, because it is technology at the end of the day, and it's better technology than what we have currently.
Thanks, Lucy. We're out of time according to the giant clock that's in front of me, but I've got permission just to talk for a couple of more minutes to keep the conversation going. Andy, you talked about Bitcoin being, crypto rather, being clean technology earlier in the context of criminal conduct. The other issue I was keen just to raise with both of you briefly was ESG, which is the other buzzword, and there's been lots of criticism of the crypto industry as being, you know, not environmentally friendly. I just wondered whether, perhaps Andy first, whether you had a view on that.
Sure. Look, a lot of the criticism is well-founded. I mean, it is, especially the way Bitcoin is designed, it is energy intensive to mine the Bitcoin that's required to validate transactions based on the specific blockchain protocol that Bitcoin uses. Many of these other coins, you know, are moving away from this particular method of validating transactions. But look, it's there. I think, you know, as to whether it has an outsized impact from an environmental standpoint, I think that really depends on what you think of Bitcoin. If the cost of Bitcoin in energy is, you know, 0.5% of the world's global energy usage, which is about what it is right now, like, is that a fair cost for what some people think is going to drive the next global revolution in finance? Maybe that's not a bad trade-off. I think there does have to be a more, and there is a more conscious movement towards renewables, towards you know, cleaner energy sources. A lot of this is going to happen inevitably as the market matures and as investors and users demand cleaner energy sources. I think it's also important to note that some of the bad press that Bitcoin has gotten in terms of the energy usage, you know, a significant portion of that energy that Bitcoin does use can't be used by anybody else. It's taps into energy sources that, because of you know, impossibility of transporting that energy to other locations, or because it is excess energy that would otherwise be wasted. You know, Bitcoin miners take advantage of that. They can put up their rigs just about anywhere in the world to tap into those energy sources. Yeah, they're going to go where it's cheap because they have financial incentive to do so. But I do think we're going to see more of a move towards cleaner energy. I think the other side of the ESG coin, and I'm sure Lucy will tap into this, doesn't get that much attention, and that is like the social responsibility of Bitcoin and the transparency that it provides in comparison to what we currently have in the global financial system. And I think, you know, that has the potential to be a huge positive for Bitcoin. The ability to bank the unbanked, the ability to have absolute transparency into where these digital assets are going. So, you know, that's something that I don't think gets enough credit from the crypto skeptics.
Thanks, Andy. And Lucy, I'll come to you in just a moment. But before I do, let's just get our final polling question up on the screen. that people have a chance to look at that while they hear your answer. And this is very much gazing into the future. The question I was keen to hear your views on is this. Cryptocurrencies will quickly replace the US dollar as the most trusted global currency. True or false? What do you think about that? And in the meantime, Lucy, what are your views on the ESG question?
I love it. We've gone from what is crypto to is it going to replace? I think
in half an hour.
A few more panels we need to convince them in between. So my views on ESG, yes. So with ESG, for me, it's pretty simple. I just look at the way that you view the world. I mean, crypto is a net positive if you look at the new infrastructure it's creating. You know, the Bitcoin network is one network, and it's an important network, but there are other networks that power cryptocurrencies that do not require the intensive proof of work, I won't go into that, proof of work mechanism that Bitcoin is known for. And the reason Bitcoin does consume energy is because of the security of the network. It's built into how the network functions. But if you take into account, has anyone done a real comparison of delivering something of value, payment and financial services between two people or across the world? You can send Bitcoin, and I can come on to corporates that are using Bitcoin because it's just quicker to get the payment done. You know, you're doing that instantly in 30 seconds from 2 hardware wallets around the world. All the infrastructure through the banking system, SWIFT, all those people you employ, all those phone calls, Teams, where's my transaction? 7 days later, still not there. You know, all the banks are full of compliance people. It just doesn't work anymore. The system is broken. And if you add up all the energy that broken system is taking, the existing banking system, and then you look at the efficiency of payments with Bitcoin, when the energy issue with Bitcoin is a solvable one, I'm sorry, someone needs to do that analysis for me to be convinced that Bitcoin is a problem for the world and not a net positive.
We may have a bit more work to do to persuade people in the audience. The answer to that question has disappeared, I think, from the screen. But in answer to that question, whether cryptocurrencies will replace the US dollar, 17% of people in the audience are die-hard fans and think, yes, it absolutely will do. 83% still need some persuasion that this is very much the future. But look, we're well out of time, I think, in relation to this session. So thank you both again for coming along. I'm sorry that we didn't have a chance to answer some of the great questions, actually, that have been coming through. I think some of the issues that have been raised, we have hopefully touched on a little bit today. I think for the others, the only thing I will say is that this was intended to whet your appetite for a future session. So please do stay tuned, and hopefully we'll come back to you with a more detailed session. But in the meantime, please join me in thanking Andy joining us from Singapore and Lucy in the room.
Thank you very much. Now we'll connect to Washington, D.C. Our very own Sarah Germer will interview the Honorable Judge Charles Brower. We are very excited to hear tomorrow's arbitrator from Judge Brower. Over to you, Sarah.
Welcome to Hong Kong, Judge Brower. It's very good to have you with us.
Thank you very much. I've been to Hong Kong a number of times, and I'm always happy to show up.
Thank you very much indeed. So everybody, it is my great pleasure to introduce to you Judge Brower, who's joining us from Washington, D.C. What we're going to do in this session is we're going to discuss with Judge Brower tomorrow's arbitrator. What is the profile? What is the skill set? What are the working methods that tomorrow's arbitrator may need to have? And the reason that we are so pleased to invite Judge Brower to have this discussion with us is because of his 50-plus incomparable career in international dispute resolution as an advocate, but also as an arbitrator and as an adjudicator. So it's my honor to introduce Judge Brower's career to you, but I do have a slight problem. Judge Brower's CV is 40 plus pages long. So that's the first challenge, but I will share with you some highlights. So Judge Brower serves as judge ad hoc at the International Court of Justice in 3 pending contentious cases. That makes him the most appointed American judge ad hoc in history, of the only 3 Americans who have ever been so appointed. He is judge at the Iran-US Claims Tribunal and continues in that role. That is one of the tribunals that has issued a significant amount of jurisprudence, particularly in the investor state area. Judge Brower was judge ad hoc of the Inter-American Court of Human Rights. He served in the US State Department 1969 to 1973, the final role being acting legal advisor. He served as deputy special counselor to the President of the United States in 1987. That was to President Reagan. And I understand, Judge Brower, you were also appointed to the Iran-US Claims Tribunal by the Bush Senior administration. He has led or been part of the executive leadership of many notable legal organizations, including the American Society of International Law, the Institute for Transnational Arbitration, the International Law Association, and the American Bar Association. He has sat in many, many significant international commercial arbitrations and investor state arbitrations, and he is also the recipient of 6 separate Lifetime Achievement Awards. I think we can probably give you a round of applause already, Judge Brower. So really the purpose of today is you're one of the giants of international arbitration, and in the past 12, 18 months, we have lost some giants of international arbitration. So it's a real honor to hear from you, your reflections on your career. And so my first question, coming back to the theme, is when you started your career in international arbitration, what was the profile of the typical international arbitrator, if you can generalize?
Well, it was generally a rather experienced male, I would say, largely from the continent of Europe, which then, of course, included United Kingdom. We thought most tribunals will be largely academics, not people from practitioners. And the very first case I handled as counsel was the first AMCO Asia arbitration, one of the really early cases at ICSID, and we had a very distinguished French professor chairing it, and one of the co-arbitrators was a very eminent Danish professor of law who later was in the cabinet. So it's changed a little bit.
So when you look back from those early days over the decades to now, what do you think are the main changes you've observed in the profile of arbitrators?
Well, I've just been listening to a little of Bitcoin for my incidental education, and I think it's a little bit like the Bitcoin business coming into the usual banking situation. I mean, there's almost a gold rush of practitioners to get into international arbitration, and you look at firms that have suddenly established practices in it because it's, as many people have said, you're in the front line of developments of something. Every day is new, as the Court of Justice of the European Community just showed yesterday, if you're familiar with that decision. So it's not such a small group of people as it was before. It's quite varied. And I would say, in many respects, the people involved are learning as they go along because it's a new field for them, including some arbitrators.
And would you say there's a distinct difference between arbitrators who come from an academic background and arbitrators who have practiced for many years? Do you see a difference in the approach to sitting as an arbitrator?
I think there is some. There, of course, are academics involved, but there are so many practitioners, some with a great deal of experience, who sit as arbitrators. The problem on the advocacy side, as I've heard from some other organizations that administer arbitrations, it's getting really nasty. I mean, people are just more aggressive in their cases. I don't know whether that's because they don't have the same respect for their fellow members of the bar who happen to be sitting as arbitrators. But in any event, it's gotten too many unjustified challenges. I myself have been in 2 cases in which all 3 members of the tribunal were challenged. In fact, one twice without success. And so there are tactics, particularly in investor-state arbitration, that we haven't seen before, and it's not as civil and gentle in a process as it was for many years.
Right. And do you think that or have you observed that there is a different skill set or working method that arbitrators need to apply these days that perhaps was not necessary in the past? I mean, we're conversing over Zoom, so these days one needs to be technically able, but have you observed any other skill sets that have become really important that perhaps were not so important before?
Well, I think always the best skill set is to have had as much experience of the world, broadly stated, as possible. Languages can come into it a bit. They certainly have on the advocacy side, not so much on the arbitrator side, because you have a simultaneous interpretation, which saves those who are not linguists from not understanding what's going on. There's a lot of debate about what COVID-19 has done via Zoom or Teams or whatever one is using. I think, frankly, net it's a blessing because it has reduced the costs to parties. It's not a boon to the arbitrators themselves because they enjoy having dinner together during the course of an arbitration and chatting about the case and getting to know each other if they haven't known each other before. But it's an enormous cost saving in airfares and hotels and so on and so forth. And I think, well, many people have observed that people behave a little differently. There's some disadvantages if you're not actually in the room. You can't see all of the faces and read their expressions and draw your conclusions. But I think it's here to stay, at least in some cases where there's less at stake.
One thing I wanted to ask you was, over the course of the last 20 or so years, we've seen quite a lot of soft law instruments come through, and these are attempts in many ways to standardize or internationalize our practices across so many different jurisdictions. Do you think that there has been a real standardization in terms of international arbitration practice over the years, or do you still think that there are quite strong splits, for example, common law, civil law approaches, in your experience?
Right. Well, I take that as 2 different questions because I have 2 different answers. certainly, in particular the IBA, various regulations or guidelines that have been put out. I don't know a case that I can remember where the IBA guidelines on the evidence in international arbitration, production of documents, and so forth, has not been adopted. Now, usually the parties are a bit shy of saying, yes, we'll be bound by them, but they'll agree to the tribunal saying, well, we use them as guidelines, and then, of course, they're applied as if they were agreed by the parties, and nobody really objects. With respect to your question about civil law versus common law, I have been involved in cases where I was with two prominent civil law lawyers, and I was on the short end of those because they simply could not. These are very intelligent people with experience abroad as well. They're so fixed in their pigeonholes, as it were, of civil law that they just could not think outside that box. A prominent example was a statute of limitations issue that arose under a New York law agreement that provided that the parties would establish a subsidiary for the purpose of taking over a refinery without specifying what law or in what jurisdiction this would be done. It happened to be a German limited liability company to own this. When it came up to a question of statute of limitations, neither my Swiss nor my German colleague could get around the fact that, oh, well, it's a German corporation, so it must be the German law and not the New York law. Well, that was, so it sometimes happens. That seems to me to be a block.
Okay, so yeah. You mentioned just earlier that you thought that what was most important for arbitrating was to have, or you thought what is important is to have experience, real world experience. I take it that practice is also a big part of that. And what we see a lot more these days is people stepping out of firms and going out on their own and creating their full-time arbitrator practice.
Right.
And what that does is it means that they are free of conflicts, but perhaps they're taking on that full-time arbitrator role at a younger age. What do you think about that?
Well, I think it's fine for the people who do it. Now, I waited until I was 65 and left the firm. Well, I continued for 5 years as special counsel, even though I was doing other things. But generally speaking, I've seen now, yes, people are doing it much younger. Of course, they're earning much more at their top law firms than they did when I was there 20 more years ago. And if you have whether you're male or female, if you have a spouse who's got a good paying job, well, maybe you're not taking such a risk. But I understand very well. When I was a partner of White and Case, I would say 95% of the requests I received to consider an arbitral appointment. In one case, I found that one of my partners out in Saudi Arabia had, billed $15,000, and that was the extent of it for doing some work which posed a conflict. And so I can tell you, and when I was asked to continue as special counsel on a salaried basis by the firm, I said, fine, that's okay, as long as I can be out of your conflicts system, which is probably of more interest to the firm, or as much interest to the firm as it was to me, and that was achieved. But it's yeah, you're going to see more and more of that. It's like it's like the surf coming in on the beach.
Yeah.
You're going to see more of it.
So, Judge Brower, we're running out of time already. How time flies. I have two more questions for you.
Yes.
The first is, you've seen so many different arbitrators over your years. For you, what is the quality, what is the most important quality that makes a great arbitrator, and that, I guess there's a second part of the question, is in a sense timeless?
I'm sorry, what was the last word?
The quality that makes a great arbitrator and that is in a sense timeless.
Yes, absolutely. I've always taken the position that the most successful international arbitrators are those who are and are seen to be totally independent, impartial, without fear or favor, no matter where they're sitting on the tribunal. Look at the facts, look at the law, and are seen by others to decide what they think is right on that basis without any bias at all. And I'll give you sort of an example. I've had reason recently to come up with how many cases have I sat in as party-appointed arbitrator in which I have decided against the party that appointed me. And it's 30%. And yet I've had zillions of arbitrations, and I'll leave the introductions to you.
Thank you very much. Final question, because we're looking to the future, tomorrow's arbitrator, would you accept payment in Bitcoin?
Wow, that came out of left field. I should have mentioned Washington. I haven't learned enough, but and anything that is convertible in some way to money that will be accepted at the bank, I will take.
I think we're okay, but I still need some education. Well, Judge Brower, thank you so much for being with us. Thank you for sharing your reflections, and I wish you all the best for the day ahead for you in DC. Thank you.
Thank you. Yes, it's almost breakfast time.
Thank you very much, Judge Brower. Now we'll connect to New York and hear the closing remarks from David Rifkin. David is a partner at Debevoise Plimpton and also HKAC's co-chair.
Thank you very much, and good afternoon to all of you attending physically in Hong Kong. Good morning or good evening to those of you who may be joining virtually from wherever you are. It's my honor and pleasure to have been invited to deliver the closing remarks for this terrific annual conference. As co-chair of the HKIAC, I'm very proud of how well the institution has maintained the excellent tradition of Hong Kong Arbitration Week throughout the pandemic. As you know, Hong Kong's example of an arbitration week has now been followed by many cities around the world. And flattery, copying, of course, is always the most sincerest form of flattery. The theme of today's conference has been tomorrow's disputes today. This is an interesting point in time to think about how our arbitration community is mapping the way forward, particularly after the changes wrought by COVID-19. COVID-19 has certainly sped up the process at which of change has been made, from the way in which arbitrations are run, the way technology facilitates them, to the types of disputes that arise. It's therefore a great pleasure today to hear our distinguished lineup of speakers, including judges, arbitrators, and practitioners, speak about the changes that have been occurring around us and what we can expect going forward as we really strive hard to get closer and closer to the ideal for international dispute resolution. HKIAC as you know, has endeavored to and will continue to endeavor to explore ways to improve the design of dispute resolution services. Sarah noted earlier that this is an important year for our institution. Indeed, I am pleased to say that the statistics that Sarah highlighted show that our past efforts in improving dispute resolution services, such as efforts in the Tribunal Secretary Services, the Tribunal Secretary Training Program, particularly our efforts to promote virtual hearings, and the interim measures arrangement, have all been quite well received by the arbitration community. Moving forward, HKIAC will continue to work with the wider arbitration community to offer better and better dispute resolution services. As you heard earlier, we've just announced 2 new projects, HKIAC Case Connect and HKIAC Case Digest. We sincerely hope that these projects will help contribute to international arbitral jurisprudence, as well as to facilitate greener, more efficient, and more cost-effective dispute resolution. Today, we discussed a number of ongoing developments that are important to the arbitration community. The interim measures arrangement in particular is a groundbreaking arrangement allowing a party to an arbitration seated in Hong Kong and administered by a qualified institution like the HKIAC to apply to a mainland Chinese court for interim relief. We heard how the arrangement works in practice, the applicable standards, the benefits of choosing Hong Kong as a seat because of the arrangement, and practical tips from practitioners and other issues that have arisen in the great success that the interim measures arrangement has been. It certainly represents a great advancement for arbitration users, practitioners, and for Hong Kong as a seat. But of course, we should continue to think about what further improvements must be made, including to strengthen cooperation between Hong Kong and mainland China, perhaps in mutual enforcement of interim and emergency relief granted by arbitrators. We also discussed important developments in Hong Kong. We mentioned, for instance, the landmark case of CVD, where the Hong Kong High Court confirmed that questions regarding compliance with preconditions to arbitration, such as negotiation periods, are an issue of admissibility rather than jurisdiction. This has a significant consequence that such questions, therefore, cannot be used as a ground for setting aside an award. This decision is a great example of the support that the Hong Kong courts regularly give to arbitration. It would be fascinating, in fact, to see a comparative study of the frequency in which awards are set aside or confirmed in major arbitration jurisdictions around the world. I have no doubt that Hong Kong would fare extremely well in any such comparative study. Our panelists also highlighted how Hong Kong jurisprudence has been relevant to their work as an arbitration practitioner in other common law and model law jurisdictions. As Hong Kong remains a popular seat of arbitration, I'm positive that Hong Kong will continue to contribute to international arbitral jurisprudence. We also talked about, and as you just heard, the development of crypto and crypto disputes. Our distinguished panel of experts discussed a number of interesting issues surrounding this relatively new form of technology, how it's defined, whether it is a currency or an asset, and how different jurisdictions regulate it. Just like any other new forms of technology, I think it's just a matter of time before the world embraces it, though I do share some of the concerns that were mentioned a moment ago about the amount of energy that Bitcoin takes. And I hope that that very much can be solved in order to focus on the benefits potential of the cryptocurrencies. Indeed, some major banks are starting to accept it. It'll be interesting to see how it may impact tomorrow's dispute resolution, especially arbitration, which is particularly suitable for this type of dispute. It remains for me to express our gratitude to the distinguished speakers today, including Judge Brower, from whom we just heard on his views on tomorrow's arbitrator, the Chief Justice for joining the Hong Kong Courts and Arbitration Panel, Dr. C of the Supreme People's Court of China for joining the Interim Measures Arrangement Panel, and of course, the Secretary for Justice for delivering the open remarks. And I want to make sure that I include, of course, the many other speakers, well-respected and busy practitioners who took the time to take part in today's discussions. It has been a day packed with interesting issues and events. For those of you participating in Hong Kong, you may have to rush off to dress up for the charity ball very soon, and I wish you well. We also have another day in Hong Kong Arbitration Week to go tomorrow, and indeed I will be delivering the keynote address at GAR Live tomorrow, and hope that many of you can join us there. I hope you all have enjoyed this year's Arbitration Week. Thank you very much for attending today, and I look forward to seeing you in person again very soon, and certainly at next year's events. Thank you very much.
If I may stop you all before you leave the room, and also a word for those who are viewing online, we have a surprise. As you know, this is the 10th anniversary of the Hong Kong Arbitration Week, and there is one person who has been integral in the organization of every single Hong Kong Arbitration Week, and indeed I mentioned her in my opening remarks as being one of the people who thought up the entire concept of an arbitration week. And that is Karen Tan, who is the Business Development Director at HKIAC. And so if you could all join me in acknowledging the immense amount of work over the last decade that Karen has done and the huge contribution that she has made to Hong Kong, that would be great. Thank you. Stand up, stand up. I think we all deserve a drink at the ball. So please thank Karen yourselves personally at the ball. Thank you.
So thank you very much for being involved today. Thank you to our wonderful speakers and the substantive sessions that we've had today. Before you put your tuxedo on and, well, glass slippers on, and head off to the charity ball, please make sure to fill in the evaluation form. Thank you. We look forward to seeing you all next year, and you can see the dates on screen. Goodbye.
A winning argument is built with carefully chosen facts, arranged in a logical structure and presented in a compelling manner. Our global practice supports arbitrations with evidence presentations, technology solutions for remote and hybrid hearings, informational and persuasive graphics. FTI's evidence presentation professionals do more than put documents on the screen. We bring evidence to life, enlarging, highlighting, and comparing documents in real time. Our technology solutions like FTI's TrialMax Cloud, a secure single-access portal for our remote or hybrid proceedings, and our remote equipment kits ensure proceedings can operate effectively. Let FTI Consulting help you successfully navigate your arbitration.